Good afternoon. Welcome to Webb County Court at Law 2. I'm Victor Villarreal, judge of your Webb County Court at Law 2. This is the family law docket for Tuesday, January 13th, 2026. The time is now 2 p.m. Court is now in session. Assisting us today are Cecia Rodriguez, court administrator and interpreter. Ms. Cynthia Flores is the family law court coordinator. Video conference co-hosts this afternoon include Ms. Rodriguez, Ms. Ramos, Ms. Cuellar, and Ms. Rivera. These proceedings are being electronically recorded. Everyone is instructed not to record any portion of these proceedings. Only a court reporter may provide the official record. As with all proceedings, violation of these instructions are subject to contempt hearings. If you're joining us online, you're instructed to act as though you were in court because you are in court. The rule here is simple. If you would not do it in person, don't do it online. For example, do not operate a motor vehicle. There is no smoking, no chewing gum, wear appropriate clothing, and always exercise proper courtroom decorum. The court will now call the cases in the order of appearance of counsel, first those in person, and then those online, as measured by your login times. Ms. Flores.
First in person, counsel Agustin Ferreira, page 5, number 12.
Adrian Garza versus Karim Verástegui, cause number 2025 FLA 1412C3. Good afternoon, Mr. Ferreira.
Good afternoon, Judge.
Court marks you present in person, Guillermo del Barrio, or parties, Adrian Garza, Karim Verástegui. Are the parties or any other person present? Please step forward if you're present.
I believe Mr. Del Barrio is in County Court 1. I need to confer with them before we give the formal announcement so we can be placed on recall.
Sure. Speak into the microphone. Are you Adrian Garza? Let's make sure the microphone is turned to on.
I gotta push it. Yes, sir.
Welcome to court, Mr. Garza. The court marks you present in person. Your spouse's lawyer says that your lawyer is in County Court at Law 1. Are you Karim Verástegui?
Yes, sir.
Welcome to court. The court marks you present in person. Your lawyer is on your right. The court is going to give the lawyer some time to talk, confer, and when they have an announcement or they're ready to have a hearing, the court will call this case. Have any questions, Mr. Garza? Ms. Verástegui?
All
right, without knowing anything else, this will be the first matter on the court's docket today. Good luck.
Thank you.
Next in person, counsel Julio Garcia, page 5, number 14.
Jessica Cruz Salazar versus Aaron Salazar, cause number 2025 FLA 1430C3. Good afternoon, Mr. Garcia.
Good afternoon, Judge.
Court marks you present in person. Madeline Escoto, Jessica Salazar, Aaron Salazar. Any other persons present?
Your Honor, if I may.
Give me 1 second. I believe Ms. Garcia is attempting to make an appearance.
Sorry about that, Judge. I didn't have my camera up. But yes, I'm appearing for Ms. Escoto.
Court marks you present participating by video conference on behalf of Mrs. Escoto. Ms. Garcia. Mr. Garcia, go ahead.
Yes, Your Honor. I had been contacted by Mrs. Escoto's offices advising me that she was requesting additional time as there was an emergency family matter that she had to tend to. I have no objection as to the request. I've advised my client of the same, and he has no issue with that as well. And just for the record, Mrs. Escoto and I are still exchanging inventories and doing a little bit of discovery so we can try to settle as many matters before we come to the court.
Anything to put on the record, Ms. Garcia?
What is the cause number, Judge?
2025 FLA 1430C3, page 5, case 14.
Okay. Yes, I think maybe a 2-week reset. Is that okay, Mr. Garcia?
I think that's fine, Judge. And we'll, if for whatever reason it's not, Judge, we'll contact your offices. But we're still in the midst of trying to settle the matter.
Give us the next available setting, Ms. Flores.
February the 10th at 2 p.m.
Thank you.
Request is granted. Any other cases for Mr. Garcia?
Not according to my list, Your Honor.
Thank you, Your Honor. May I be excused?
It's good to see you. Have a
too,
great
Thank
rest of the
you.
year.
Yes, thank you, Judge.
Happy New Year.
Thank you. I'll stand by for Mrs. Cotto's cases, Judge.
Thank you, Ms. Garcia.
Next in person, Council Eduardo Romero, page 7, number 19.
Eusebio Garza, Cynthia Raquel Ramirez versus Daniel Salinas, cause number 2025 FLF 634C3. Good afternoon, Mr. Romero.
Good afternoon, Your Honor.
Court Martial present in person, Juan Jose Garcia. Counsel Garcia, are you present? Court marks Mr. Garcia not present. Are you Eusebio Garza?
Yes, sir.
Welcome to Court, Mr. Garza. The Court marks you present in person. Are you Cynthia Raquel Ramirez?
Yes, Your Honor.
Welcome to Court, Ms. Ramirez. Court marks you present in person. Daniel Salinas, are you present? Court marks Mr. Salinas not present in person, not present by video conference, and court takes judicial notice that he was served with process by publication on May 13th of last year. Mr. Garcia, court marks you present and participating by video conference. Announcement, Mr. Garcia?
I believe we're ready to proceed, Your Honor.
Mr. Romero, are you ready?
Yes, Your Honor.
All right. This is a termination and adoption, Mr. Garcia?
Yes, Your Honor.
All right. Who is your first witness?
My client, Your Honor.
You have two. Who is your first witness?
Mr. Garcia, Your Honor.
Mr. Garza, would you raise your right hand, please? Do you solemnly swear or affirm that the testimony you will give in this cause will be the truth, so help you God?
Yes.
One more time, much louder into the microphone.
Yes.
All right, you may lower your hand. Just step up really close to the microphone. Pull it into your mouth as close as possible. Mr. Garcia will ask you some questions. Mr. Garcia.
Thank you, Your Honor. Can you state your name for the record?
Eusebio Garza.
Okay, and what is your relationship to the child?
I'm his uncle.
Okay, and you're looking to adopt the child?
Yes.
Okay, and who is the mother of the child?
Emily Garza.
Okay, and why are you seeking the adoption?
She passed away and he doesn't have anybody else.
Okay, and Cynthia Raquel Ramirez is right now married to you?
Yes.
Okay, and the child is Javier Tomas Garza?
Yes.
Okay, and he's approximately 2.5 years old?
Yes, sir.
And how long has he been living with you?
More about a year and a half.
A year and a half, okay. And so the reason that you were asking for termination between the father, who is Daniel Salinas?
He was never present for him. And we
Okay.
don't know that.
So, and did he ever provide that you go?
Repeat the last part of your answer really much louder.
We don't know where he's at.
I
And
apologize,
did,
Mr. Garcia, go ahead.
thank you, Your Honor. And did at any point, as far as you know, was there ever any child support paid from the father to the mother?
No, they were still they were gonna go to court for that, but she passed away.
Okay, so there's been, in all these years, there has not been any support from the father to the child in any way that you know of?
No, sir. None at all.
Okay, and the father has not had any kind of relationship with the child?
He's never seen him.
Okay. And so you are looking to terminate the parent-child relationship between the father and the child, is that correct?
Yes.
Okay, and why do you believe that's in the best interest that that relationship be terminated?
He was never there for him. He doesn't even know who he is.
Okay, and you are requesting that you adopt the child, is that correct?
Yes.
And you're also asking that Cynthia Ramirez adopt the child, is that correct?
Yes.
Okay, and are you also asking for a name change for the child?
No name change.
Okay, so you want the child name to remain the same?
Yes.
Okay, and why do you believe, and are you also aware, Mr. Gasa, that by adopting the child, there will be also certain rights and duties that you're gonna have?
Yes, I'm aware.
Are you aware that you would also have to pay in case there's ever a divorce or separation, anything, you might have to pay child support?
Yes, I understand.
Okay, and even knowing that, you're still wanting to go through with the adoption?
Yes.
Okay, I have no further questions, Your Honor.
Mr. Romero, any questions for Mr. Garza?
No, Your Honor.
Other witnesses, Mr. Garcia?
Just Cynthia Raquel Ramirez, Your Honor.
Ms. Ramirez, would you raise your right hand, please? Do you solemnly swear or affirm that the testimony you will give in this cause will be the truth so help you God?
I do.
You may lower your hand. Mr. Garcia, go ahead.
Thank you, Your Honor. And you just heard the testimony that Mr. Garza did?
Yes,
Are you in agreement with all that testimony?
yes.
And why is it that you wanna adopt a child?
Because he'll be in a stable, loving home
Okay, and how long have you been taking care of that child?
for about 1.5 years now.
Okay, and you're asking that the rights be also of the father and mother be terminated, is that correct?
Correct.
Okay, at this point, I don't have any further questions, Your Honor.
Mr. Romero, do you have any questions for Ms. Ramirez?
No, Your Honor.
Your report, Mr. Garcia, any other witnesses?
No, Your Honor.
Mr. Romero, your report and recommendation.
Yes, Your Honor. The court appointed me as the attorney ad litem for Mr. Salinas. I searched for him in the Lexus database. In speaking with Mr. Garza, he provided me with the last known address of Mr. Salinas, which was 1815 Flores, Laredo, Texas. I sent him a certified letter and also via regular mail notifying him of my order of the petition for termination, and also gave him a copy of the notice of hearing. A copy of said letter was filed with the court. The court has already called his name. He has not made an appearance. And therefore, I believe that the court has jurisdiction and should go forward with the case, Your Honor.
All right, final thoughts, comments, arguments, and requests, Mr. Garcia.
We're just asking if the parental rights between the father and the child are terminated, Your Honor, and if both my clients can adopt. And I think they're also asking for a sealing of the courts of the records, Your Honor.
Any response to any of this, Mr. Romero?
No objection, Your Honor.
I guess before the court pronounces and render, Mr. Romero, anything to put on the record or make a request or put into testimony or into the record regarding attorney's fees?
Your Honor, the court had ordered for the parties to deposit $750. Mr. Garza has paid $500. He's just pending the $250 now.
Response, if any, Mr. Garcia?
None, Your Honor, no objection.
All right. Mr. Garza, before the court makes a decision and pronounces and renders, is there anything else you would want to tell the court? Court has heard no. Ms. Ramirez, same question. Anything else you want to say?
No, Your Honor.
All right. Mr. Garza, Ms. Ramirez, in this case, cause number 2025 FLF 634C3, the court at this time finds that it has jurisdiction over this case, meaning this is the proper court form and venue to consider the termination of these parental rights and the adoption if the court terminates the rights. The court having found it has jurisdiction, the court takes notice that Daniel Salinas was served with process. By publication on May 13, 2025, the court has heard the testimony and the report of the court-appointed attorney ad litem. The court finds that diligent searches have been made both through an electronic database, through certified letters, and there has been no success. The court finds, therefore, that it has jurisdiction. The court at this time finds that this child, Javier Tomas, has lived with you for at least 1.5 years. He is now a year, 2.5 years old. The court finds that Mr. Salinas has had no contact. He has not been present. His whereabouts cannot be located. He has not paid child support now, or has he ever. The court finds that he has no relationship with Javier Tomas, and he has never seen him. I find that you have met all of the requirements under Texas family law to grant your request. The rights of Daniel Salinas are hereby terminated. The court finds that the remaining $250 balance due to Mr. Romero is due owing reasonable right, just, reasonable and necessary in attorney's fees. And it's agreed to, so ordered. Regarding the adoption, Mr. Garza, Ms. Ramirez, the court finds that over the last year and a half, you have provided Javier Tomas a good, caring, loving, and stable relationship. The court now gets to do in the legal world what's already going on in the real world, and that is to grant the adoption and to name you as his parents. Congratulations. These are the orders of the court, and these orders are due honor before
January 26th at noon by submission.
the court finds that doing this is in Javier Tomas's best interest. I wish your family all the best. Good luck to you.
Thank you, sir.
Anything else on this case, Mr. Garcia?
No, Your Honor.
Mr. Romero?
No, Your Honor.
I wish you good. I wish you all the best. Good luck.
Thank you, Your Honor.
Next in person is Counsel Olivero Canales, page
No more-
5, number 13.
No more cases for Mr. Romero?
None for Mr. Romero, further down the line for Mr. Juan Garcia.
Have a great day. Happy New Year.
Thank you, Your Honor.
Page and case for Mr. Canales?
Page 5, number 13.
Fernanda Marfil versus Gerardo Garza Rodriguez, cause number 2025 FLA 1427C3. Court marks Mr. Canales present in person. Speaking to the microphone and tell the court, are you Fernanda Marfil?
Yes, Your Honor.
Welcome to court, Ms. Marfil. The court marks you present in person. The person to your left is your lawyer. Gerardo Garza Rodriguez, are you present? Court finds that Respondent Rodriguez is not present, and the court takes judicial notice that he was served with process on October 24th, 2025. Mr. Canales.
Yes, may I proceed?
Ms. Marfil, would you raise your right hand, please? Do you solemnly swear or affirm that the testimony you will give in this cause will be the truth, so help you God?
Yes.
You may lower your hand. Mr. Canales, go ahead.
Yes, is your name Fernanda Marfil
Yes.
and you were married to Gerardo Garza Rodriguez?
Yes.
Okay. Have you lived in the state of Texas at least the last 6 months?
Yes, I have.
And have you lived in Webb County at least the last 90 days?
Yes.
And were you and your husband married on November 15th, 2019?
Yes.
And you've been separated since August 15th of 2023?
Yes.
Is there a conflict of personalities between you and your husband where you can no longer live together as husband and wife?
Yes.
In fact, he is incarcerated at this point, is that correct?
Yes, he is.
Okay. Now, of this marriage, you had 5 children, is that correct?
Yes.
And all 5 children were born in Laredo, Webb County, Texas?
Yes, they were.
Are their names Gerardo Garza Jr., Mariano Fernando Garza, Renata Garza, Ivan Garza, and Regina Mary Lou Garza?
Yes.
Okay. And they all live with you, is that correct?
Yes, they do.
As far as the children, are you asking that you and your husband be named joint managing conservators, but that you will have the right to establish the primary residence of the children?
Yes.
Okay. Now, are you also asking for child support once your husband is released from jail?
Yes.
Okay. And are you asking the court to assess the minimum under the Texas child support laws
Yes.
for 5 children?
Yes.
Okay. And do the children have Medicaid?
Yes, they all do.
Okay. And you're asking the court to assess medical child support for your husband to pay in the amount of whatever the minimum is. I don't know if it's $50 or whatever the minimum is.
Mhm.
And as far as property, you have not bought any real estate together, is that correct?
No.
Okay. And are you asking that you keep whatever personal items you have and that your husband keep whatever personal items he may have?
Yes.
And as far as any debts that you may have, that he keeps whatever debts he has in his name and you keep whatever debts are in your name?
Mm.
Okay. And do you still want the divorce?
Yes.
I believe those are all the questions I have for Ms. Marfil.
Good question. First question, anybody here in the virtual well on behalf of the Attorney General's office?
Good. Yes, Your Honor. Elias Alcantara, the Office of the Attorney General.
Mr. Alcantara, 2 questions. You heard the testimony. Do you know child support calculation of minimum wage for 5 children?
For 5 children? If you could give me a few moments, Your Honor.
Sure.
And I apologize. I don't believe I had this on my calendar.
It isn't. I know if somebody here knows the answer, you would.
Okay. So child support and minimum wage. I heard $50 for medical. Is that correct?
Well, that was the testimony, but my second question to you is going to be, is that what the state would suggest, recommend, and ask for Medicaid for 5 children?
Usually we request 57, which is half of the 9% for minimum.
57 total?
For medical total, yes.
All right.
Child support for 5 children, and I didn't hear any testimony as to him having any other children, so it's going to be only these 5.
Right.
Would be at $441.
All right. Any thoughts, comments, responses, or objections to that number, Mr. Canales?
No, yeah.
All right. Ms. Marfil, anything else that you would like the court to know? Ms. Marfil, in your case, cause number 2025 FLA 1427C3, the court at this time finds that it has jurisdiction over your case, meaning this is the proper court form and venue to consider your divorce. The court finds that you entered into marriage with Gerardo Garza Rodriguez on the 15th day of November 2019, but you stopped living together as husband and wife on the 15th day of August 2023. The court at this time finds that your marriage has become insupportable due to a discord or a conflict of personalities that destroys the legitimate ends of the marriage relationship. The court finds that there were 5 children born of the marriage. No other children were born, adopted, or are expected. The court hereby names both you and Mr. Rodriguez as joint managing conservators, which means that both of you have the same rights, duties, responsibilities, and obligations over your children, except that you, Ms. Marfil, will have the exclusive right to determine their residence. Child support is hereby set at $441 per month beginning on February 1st, 2026, with a $57 reimbursement to the state for Medicaid and health insurance. The court does this and finds that doing so is, in fact, in the interest of all of you, in the best interest of all of your children. The court finds that there is some community property to divide. The court hereby awards all of the property in your possession is hereby awarded to you, and all of the personal belongings in Mr. Rodriguez's possession are hereby awarded to him. The court finds that this is a just and right division. At this time, Ms. Marfil, the court finds that there is no reasonable expectation of reconciliation, and the court hereby renders and pronounces you divorced. These are the orders of the court, and the orders are due on
January 26th at noon by submission.
anything else for the record, Mr. Canales?
No, yeah.
Do you have any questions for the court, Ms. Marfil?
No, Your Honor.
I wish you well, but I wish your children all the best. Good luck to you.
Thank you.
Any other cases for Mr. Canales?
No, Your Honor.
Thank you, Mr. Canales. Have a great year.
Next in person, counsel Juan Hernandez, page 6, number 17.
Arlene Caldera versus Marcos Caldera, cause number 2025 FLB 1441C3. Court marks Mr. Hernandez present in person, Ms. Claudia Lanese Garcia present by video conference. Filling in for Mrs. Cotto, Arlene Caldera, Marcos Caldera. Are the parties present? Court finds parties not present. Mr. Hernandez, Ms. Garcia, go ahead.
Good morning, Judge. I believe Mr. Hernandez agreed to a continuance that Ms. Escoto is requesting.
Mr. Hernandez, inaudible.
One more time. Mr. Hernandez. And you said that was correct.
That
is
correct, Judge.
Okay, I'm sorry. I couldn't hear. Thank you. From the notes that I have, and I'm not sure if it's possible, I'm not sure if that was Mr. Hernandez's agreement, but Ms. Escoto asked me to request a 1-week reset.
That's fine. We have.
So we have a week. How many cases do we have on the 28th? Is this a prove up?
We're about halfway negotiating it, Judge. We should have a fairly simple case.
Well, I think I understand the request, but if it's not a prove up, I guess I tell you what, Ms. Flores, I know I heard the date that you gave earlier. Set that as a final hearing, but give me the 28th as a final pretrial.
January 28th at 9 a.m.
That's a final pretrial hearing, and give us a TOM date, trial on merits.
February the 12th at 9 a.m.
All right, I'm sorry, the 12th? Or the 10th?
February the 12th.
Okay, I'm sorry, the other case I had understood the 10th. But, okay, I'll
yes,
change that.
My apologies, Ms. Garcia. That would be February the 12th.
Okay,
At 2 p.m.
okay, thank you.
All right. Any other anything else on this case, Mr. Hernandez?
Not on this case.
Any other cases for Ms. Hernandez?
Yes, page 8, number 20.
Thank you, Judge. I'll stand by.
Thank you. Robert William Slaughter versus Mexico Moving Company LLC, Reina Madrigal Martinez, cause number 2023 CVI 1507C3. Court marks Mr. Hernandez present in person, Ms. Soto present by video conference. Are you Robert Slaughter?
Yes, Your Honor.
Welcome to court, Mr. Slaughter. Court marks you present by video conference. As you can see and hear from your device, your lawyer is also present and participating by video conference. Reina Madrigal Martinez, Brett Green, or any other person present on this case. Court finds no other persons are present in person or by video conference. I think this is your motion, Ms. Soto. Announcement?
It is, Your Honor, and just briefly, Mr. Green did call my office earlier. He was having trouble contacting the court. He is not the subject of the motion, and he had court in Kendall County, so he didn't want to let the court know he was not going to be showing up. He has no position on my motion.
Understood.
I do need a hearing on my motion, Your Honor. Mr. Hernandez did file a response, so we don't have an agreement on the motion.
All right, I'm going to place you as the second contested matter. Without further inquiry, Ms. Soto, how much time would you anticipate this contested matter taking?
I would think no more than 20-30 minutes, Your Honor.
Is that approximately your estimation, Mr. Hernandez?
Your Honor, I thought it'd be over in about 3 minutes.
All right. So I don't know if this is zero sum. If it's zero sum, then there's no room to negotiate, right? Because you either win or you lose. I don't know if there is. If there's any wiggle room, please talk to each other. If there isn't, I'll call this case shortly.
Well, you know,
Yes.
the issue is it's a reconsideration, guys. I mean, there's nothing in the new motion to reconsider than what the court has already heard the last time.
And actually, there is, Your Honor. I did file an affidavit proving up the attorney's fees, the time spent, and I believe that in the response, Mr. Hernandez continued to cite inadvertent calendaring error, and I don't think that was what happened on the second occasion where he canceled the mediation the day before it was to take place.
So if it isn't zero sum, and if you're asking for some fees, it's not 0 or 100. There's something that you can talk about, not that you have to agree to anything, but it's not zero sum. I suggest you all talk. All right. You can argue momentarily, folks. Let me continue with this docket.
Next in person, Counsel Benavides Maddox, standing in for Counsel Rubio, page 1, number 1.
Fernando Vasquez, Yvette Josephine Vasquez, cause number 2003, CVG 1233C3. Court marks Ms. Benavides Maddox present in person on behalf of Ms. Rubio. Good afternoon, Ms. Maddox. Fernando Vasquez, Yvette Josephine Vasquez. Any parties present? Court finds no parties present. Ms. Maddox, go ahead.
I filed a unopposed motion for continuance and also a Rule 11 agreement subject to the court's approval. I met with Ms. Cigarroa and also with Leticia Garcia, who's the ad litem for the children. And Ms. Garcia has requested more time to conduct her interviews and investigation. I'm not sure if the motion for continuance has been filed, but I know that we signed off on it and sent it back to Ms. Cigarroa's office for filing.
She's referring page 1, number 2, Your Honor. We called page 1, number 1.
Oh, I'm sorry.
Correct. Yeah.
I'm so sorry.
No worries. So this is another case. This is the Vasquez matter. In that case, respondent was just served yesterday.
Correct.
So Ms. Flores, give us 20 days plus a Monday. So no sooner than 27 days.
How much time you on? I'm sorry.
30 days, at least.
That would be,
Oh, I didn't even ask because apologize. Ms. Maddox, how much time is Ms. Rubio requesting? She may be requesting more. I don't know.
No, I think the 30 days
Okay.
is fine, Judge, and if necessary, I'll reappear for her.
Okay. Ms.
But I
Flores.
know that she wants this matter to be handled expeditiously.
Sure. Well, give us the next available after 30, please.
February the 12th at 9 a.m.
All right.
And can we verify that the name was called and that there was no response?
I
That-
see her in the wall of the court, Your Honor.
Yvette Josephine Vasquez, are you present?
I am your judge. Yes. Yes, I am here.
The reason I'm not responding is because you haven't started your video, so I can't prompt you. I can't see you. I can't prompt your video and I can't see you. So start your video, please.
Okay, yes, I didn't get that prompt. I'm sorry. I'm here.
Are you Yvette Josephine Vasquez?
I am.
Welcome to court, Ms. Vasquez. The court marks you present. You're participating by video conference. Ms. Vasquez, do you have a lawyer?
I do not. I signed in today to request more time as well because I was just served yesterday.
Sure, sure. The court is going to call this case on February the 12th. That gives you sufficient time to hire a lawyer. Two things. First thing, Ms. Vasquez, what is your email address?
dy15@icloud.com.
One more time in case we missed anything.
dy15@icloud.com.
Now, be on the lookout in your emails because if the court needs to send you in for any information, any notices, or if Ms. Rubio needs to do the same, it's likely to go to that email address. Second thing, Ms. Vasquez, the best thing that I can tell you in the interest of moving this case forward is if you do consider hiring a lawyer, and you don't have to, that is your right. If you do, please do so as soon as possible. If you wait till a day or two, even a week before, that may be insufficient time for a lawyer to consult with you, give you the best advice, prepare you for your case, and to be fully prepared to represent you in court. Do you understand all of this, Ms. Vasquez?
I do understand, Judge.
Do you have any questions for the court?
No, I do not. Thank you.
All right, we'll see you on February the 12th at 9 a.m. Good luck.
Thank you.
Ms. Rodriguez.
Page 1, number 2.
Daniel Garcia versus Ana Karen Manrique, cause number 2012 CVL 325C3. Court marks Ms. Adriana Benavides Maddox present in person on behalf of Ms. Rubio, Ms. Leticia Garcia present and participating by video conference.
Good afternoon, Your Honor. This is Tony Taylor. I'm here on behalf of Marty Ciarroa, and we represent Ana Karen Manrique.
Welcome to court, Ms. Taylor. The court marks you present. You're participating by video conference. Are you Ana Manrique?
Yes, Your Honor.
Welcome to court, Ms. Manrique. The court marks you present. You're participating by video conference. As you can see and hear from your device, so is your lawyer. Daniel Garcia, are you present? Court finds Mr. Garcia not present. Ms. Maddox, Ms. Taylor.
Judge, I am present for Mr. Garcia and also for Ms. Rubio. And we have, as I previously stated, I apologize. I had my cases, Julia's cases in the wrong order on my docket. And so this is in fact the case where we filed a Rule 11 agreement and a agreed verified motion for continuance so that Ms. Garcia can have some more time to conduct her interview and her investigation.
Ms. Taylor.
Yes, Your Honor, it's unopposed. I have no objection.
And Ms. Garcia.
Good afternoon, Judge. Yes, that's correct, Judge. I just need about a week to 10 days. I have spoken with the children. I have spoken with both parents, but I do need to have a sit down to finalize some issues.
All right. Well taken on all fronts. Ms. Flores, give us that same date in February, please.
February the 10th at 2 p.m.
You know what? This is a final pretrial, though. Is that that's fine because it's set for final hearing on February the 24th. Let's not release that date. So final pretrial hearing February the 10th at 2, and then final hearing on February the 24th, both at 2 p.m. Anything else on this case, Ms. Maddox?
No, Your Honor. And if Ms. Cigarroa or Ms. Garcia need to get a hold of me, in case they can't reach Ms. Rubio, I'm happy to assist them in any way to
Well
move
take-
this case forward.
Well taken. Anything else on this case, Ms. Taylor?
No, Your Honor.
Ms. Garcia?
No, Judge, thanks.
Ms. Manrique, do you have any questions for the court?
No, Your Honor. Thank you.
Unmute your device and tell the court, are you Daniel Garcia?
Yes, Your Honor.
Start your video, please, and unmute your device. There's an unmute button at the bottom left of your screen. Microphone or red button. Go ahead and press that button without turning off your video.
Can you hear me, Judge?
Sure can. Are you
I
Daniel
was having
Garcia?
trouble with the phone. I'm sorry. I apologize. Yes, Your Honor.
Welcome to court, Mr. Garcia. The court marks you present and participating by video conference. As you can see and hear from your device, Ms. Rubio is not present, but Ms. Adriana Benavides Maddox, lawyer, counsel Maddox, is here for her. They have presented the court with an agreement to reschedule this setting. The court has granted the request and scheduled this for February the 10th at 2. And then the original date still continues to be set for February the 24th at 2. Do you have any questions for the court, Mr. Garcia?
No, I don't, Your Honor.
All right. Mr. Alcantar, on behalf of the Attorney General's office, anything to add?
No, Your Honor, no objection.
All right. Thank you all. Everyone on this case is excused on this matter.
Thank you.
Your Honor.
I have no other matters before the court, nor does Ms. Rubio, maybe.
Have a good day. Happy
Thank
New
you.
Year.
You too, Judge.
Next in person is Counsel Javier Montemayor, page 3, number 8.
Julio Cesar Villasana versus Joanna Elizabeth Rangel, cause number 2024 FLC 1931C3. Good afternoon, Mr. Montemayor.
Good afternoon, Your Honor. Javier Montemayor, present for Mr. Villasana.
Yes, sir. Court marks you present in person. Speak into the microphone and tell the court, are you Julio Cesar Villasana?
Yes, Your Honor.
Welcome to court, sir. The court marks you present in person. The person to your left is your lawyer. Are you Joanne Elizabeth Rangel?
Yes, Your Honor.
Welcome to court, Ms. Rangel. The court marks you present. You're participating by video conference. Ms. Rangel, do you have a lawyer?
No, I don't.
Will you be going forward without a lawyer?
Yes, Your Honor.
All right, the court marks you self-represented. I guess because of a procedural issues, Mr. Montemayor, this is the third temporary order setting and fifth SAPSR setting. Announcement?
Your Honor, I'm not sure what Ms. Rangel is thinking, but this is it's a SAPSR hearing. We are asking that Mr. Villasana be appointed the party with the right to determine the primary residency of the child. In the alternative, we're asking for a temporary order today. In the interim, Mr. Villasana received the child over the holidays and has taken the child to get some medical treatment and evaluation, and the child has been referred to a doctor, Norberto Alvarez, for some panic disorders and some anxiety episodes that the child has been suffering, and we think it's because of where she's living and where she's coming from. If Ms. Rangel wants to proceed without the benefit of a lawyer, the judge last week released her prior lawyer from this. We had been negotiating with him extensively, and he just withdrew.
I think that's why I did that. I think I purposely said it before. In other words, what I didn't want Ms. Rangel, Mr. Villasana, Mr. Montemayor, I didn't want to come to the final hearing not knowing if Ms. Rangel was going to have a previous lawyer, no lawyer, or a new lawyer. So now we know that this court, through another judge, excused Attorney Parra, and that now Ms. Rangel has chosen not to hire any other counsel and has decided to be self-represented. So knowing all of that, Mr. Montemayor,
Judge, then we'll proceed this afternoon. The court wants to put us down for the third contested hearing, and I'll get some testimony from Mr. Villasana.
Mr. Angel, well, I need to know if this is agreed to or not, Mr. Angel. So the request at this juncture is either to put in place some temporary orders, I guess based on what's happened over the holidays and some referral to a new medical professional, or to hold a final hearing and allow, I guess, in the best interest of the child, for this child to live with Mr. Villasana. Do you agree or do you disagree with any of those requests?
For Your Honor, honestly, I wasn't aware of the situation. Like, me and Mr. Villasana and we have really hard time communicating with each other. All this happened from one time to another. I did reach out to Juliet's school teachers, counselors, and they also responded the same, that there was nothing aware. They weren't aware of her behavior. She acts perfectly fine here at school and everything. He did relocate Juliet without my consent to Laredo during this period of time.
So let me stop you, because my question wasn't, I didn't mean to elicit any facts. I can hear the facts, whatever you believe they are and whatever Mr. Villasana believes they are, if you don't have an agreement. If you do have an agreement, what I need to know is whether you agree with either one or none of his requests. And I'm telling you again, as you heard, his requests are either a final order that allows him the exclusive right to determine your child's residence, or temporary orders that allows him to do that and take the child for a medical evaluation with this new medical professional. Do you have an agreement as to any of those?
No, Your Honor.
Okay.
I disagree. Yes.
So now I know that we're going to have a contested hearing then. All right. So this will be the third case on the court's contested docket today. Mr. Montemayor, you know it's the court's policy, but do you believe any communication with Ms. Rangel would be fruitful?
No, Your Honor. I've had communication with her and in the past when this first started, and it was not fruitful at all. And at this juncture, I don't think it will be. What I could suggest to the court is that the court perhaps would like to appoint an ad litem in this case. I did not file a motion to that effect, but one has not been appointed on this case. And, I did upload as part of the evidentiary requirements the documents to support our position on the medical situation of the child. But
I'll tell you what the court's preference is. I think that's where we're going to end up. I could, that'll make the court's job easier, and that'll give me some extra time this afternoon. However, if I did that, I would kick the can down the road, and I would find ourselves without final answers after today. So no, I think, so we're going to go forward today, Ms. Rangel. The court will make a decision after hearing your testimony, Mr. Villasana's. All right, stand by.
thank you.
Thank you.
Next online is Council Juan Garcia. Page 2, number 5 and 6.
There are companion cases. First case is Selena Palacios versus Andres Mata, call number 2014 CVW 15C3. The companion case is Andres Mata versus Selena Palacios, cause number 2025 FLE 1184C3. Good afternoon, Mr. Garcia.
Good afternoon, Your Honor.
Court marks you present. You're participating by video conference. Court marks Mr. Elias Alcantar present and participating by video conference on behalf of the Attorney General's office. Are you Selena Palacios?
Yes, Your Honor.
Welcome to court, Ms. Palacios. The court marks you present in person. Ms. Palacios, do you have a lawyer?
No, Your Honor.
Are you going forward today without a lawyer?
Yes, Your Honor.
Court marks you self-represented. Are you Andres Mata?
Yes, sir.
Welcome to court, Mr. Mata. The court marks you present in person. As you can see and hear from this device, your lawyer is present and participating by video conference. Are there any other persons present on this case? Court finds no other persons are present. Mr. Garcia, what is the announcement in both cases?
On this case, Your Honor, I believe the respondent didn't have an objection to my client terminating his parental rights.
Ms. Palacios, you heard the representation of Mr. Mata's lawyer. Do you have an objection to the termination parental rights for Mr. Mata?
No, Your Honor, I was just gonna ask if they were gonna change my daughter's last name.
Well, they don't decide. I will make that decision and he won't have a say really in the matter. It really depends on what the court finds momentarily. I guess I'm here for Mr. Alcantar. Anything on behalf of the Attorney General's office?
No, Your Honor, and we did file a motion to confirm arrears if the court does grant the termination. And generally, we object to termination unless there's also an adoption.
Mr. Garcia, is there an adoption pending?
No, Your Honor, it's just a termination of my client's rights.
We did agree if I was gonna terminate the rights that Mr. Mata had to change his last name, and the lawyer, Mr. Garcia, and Mr. Mata did agree to do that in order to terminate his rights.
Well, they can agree, and the agreement would be to make the request of the court, and the court needs to figure out whatever is in the child's best interest. But before I even do that, there's an objection by the Attorney General's office, and the objection is that they won't agree. I mean, I can still grant it if there's a good cause reason basis and it's in the best interest of the child, but their policy is to object to all terminations if there's no adoption. And I guess let me ask this, Mr. Alcantar, there is a pending filing from the Attorney General's office to confirm arrearage, is there not?
Yes, Your Honor, that's correct. And it's set for today as well.
Right. So let me ask you this, Mr. Alcantar, Mr. Garcia, Ms. Palacios, and Mr. Mata. Why doesn't the court first do the confirmation of the arrearage, and then we'll take up the termination? Any objection to that, Ms. Palacios?
No, yeah.
Any objection to that, Mr. Mata?
No, sir.
Mr. Garcia?
No, Your Honor.
Mr. Alcantar?
No, Your Honor.
Mr. Alcantar, this is your motion on confirming. Go ahead.
Yes, Your Honor. Your Honor, we're asking that the court find that he is in child support arrears of $227.13 as of today's date, January 13th, 2026. Medical support arrears of $0. And then as to any modification, we don't have any if the termination is going to be granted, of course, we're going to ask that child support stop. But if it's not, then we're not going to ask for any changes to the modification for his current support.
I'm sorry. So I guess
they're kind of related, yeah.
Let me take up and consider well, no, because you're asking for it to be modified here, but you're not asking for that modification unless there's a termination.
Correct. If there is not, then just ask that we not see the modification and just confirm arrears only.
All right. And you said that amount is 227, what?
And 13 cents, 13.
Mr. Garcia, any objection to that confirmation?
No, Your Honor.
Ms. Palacios, any objection to that confirmation?
No, Your Honor.
The court hereby confirms in cause number 2014 CVW 15C3 by statement from the Attorney General's office, the non-objection and acquiescence and agreement by all parties that arrears should be and are hereby confirmed at $227.13. Arrears so confirmed. All right, so now we move on to the termination. Let me first hear the objection. Mr. Alcantar, on behalf of the Attorney General's office, what is the specific objection to proceeding with the termination?
Your Honor, we do not believe it is in the best interest of the child that the court grant termination unless there is also an adoption.
This petition was filed by Mr. Mata. Mr. Garcia, response to the objection?
Our opinion is that there is it is in the best interest of the child for the termination to go through, Your Honor, and we can present evidence as to why from testimony from our client.
Ms. Palacios, would you like to respond to the objection regarding not proceeding with a termination unless there is also a corresponding adoption?
Mm. Yeah. Only my husband can adopt her.
Is that something that has been contemplated?
No, I hadn't. He's the one who came about terminating his rights. He's the one who brought me.
I'm sorry, when you say husband, are you referring to Mr. Mata?
Yeah.
So another gentleman.
Yeah.
Hmm. I guess before we get into evidence and testimony, Ms. Palacios, how old is this child?
She's 13.
The thought, the idea of your husband adopting your 13-year-old, has that conversation ever taken place in your house?
Yes, Your Honor. My husband's raised her since she was 2 years old.
I tell you what I'm going to do before I tell you that decision. Let me see if Mr. Garcia has any other thoughts. Mr. Garcia, respond to the objection.
Well, we would object to the Attorney General, because we want to proceed with the termination today, Your Honor. My client, he wishes to terminate his rights. I don't think he has very little contact with the child.
All right. I understand your lawyer's position, Mr. Mata. It would certainly be in your best interest to proceed today. That absolves you, and that would get you out of any obligations, I guess financial, legal, and I guess maybe even moral, maybe not, I don't know, but you would be cut from this case. However, that isn't the standard. I mean, certainly that's your lawyer's obligation. He's doing his job. But the standard that the court has is what's in the best interest of this child. And if there are conversations going on in that house where she resides about a possible adoption, I agree with Mr. Alcantar. The court should consider those at the same time. So I tell you what, I'm going to give you folks 1 month to think about this.
I have nothing to think about it, Your Honor. I'm giving my full legal rights to them, to her and her husband.
Well, I know that that's what you want. That doesn't mean that that's in the best interest of your daughter.
I would never mention about it. Nothing. She didn't mention anything to me about them adopting.
What you shouldn't blame her because she's not the one that brought it up. So don't say that it's somehow, or don't try to insinuate that somehow it's her fault, because it's the Office of the Attorney General that's bringing up the issue, not Ms. Palacios. But we're not here for you, and we're not here for her, at least not whatever's in your best interest. We're here in the best interest of. You know these answers. I'm going to give you all a month to see, and maybe it works and maybe it doesn't, but at least these conversations in the best interest of this 13-year-old can be had. This is not about you.
Yeah.
This is about the 13-year-old. All right. The orders on the 2014 case regarding arrears are due honor before
January 26th at noon by submission.
and then we'll come back on the termination and adoption in late February.
February the 24th at 2 p.m.
Now, what this means, Ms. Palacios, if you have these conversations with your husband, and if he agrees, and you both believe, you're gonna have to testify this under oath, that this is in your daughter's best interest, you need to file something with the court to make your wishes and desires known in writing. So if that's what you want, talk to a lawyer, look for a lawyer, consult with a lawyer so that that person can be ready to go forward on February 24th. Do you have any questions for the court, Ms. Palacios? Mr. Mata, do you have any questions?
Yes, sir.
I wish you both very well. Ms. Flores.
This be an in-person hearing, Your Honor?
Yes, Mr. Mata, Ms. Palacios, be here in person. All right, I wish you well. Good luck.
Page 4, number 10.
Tomas Castillo versus Belinda Hasso, cause number 2025 FLA 799C3. Court marks Mr. Garcia, President participating by video conference, Ms. Claudia Lanesa Garcia, President participating by video conference on behalf of Madeline Escoto, Ms. Leticia Garcia, President participating by video conference. Tomas Castillo, are you present? Court finds Mr. Castillo not present. Belinda Hasso, are you present? Finds Ms. Hasso not present. Mr. Garcia, Ms. Garcia.
Good morning, Judge. I mean, good afternoon, Judge.
Yes, ma'am. Good afternoon. What is the announcement?
I believe Mr. Garcia has agreed to the continuance that Mrs. Cotto is requesting. Is that correct, Mr. Garcia?
That's correct, Your Honor.
From the notes I have, I believe the parties are requesting a 1-week reset if possible. Is that correct, Mr. Garcia?
That's correct.
This is an entry. Ms. Flores, I'm going to push this on because this is only an entry. It's either, whatever happened on the record, they need to enter that. So January 28th at 9 a.m. We're set for entry, third setting for entry.
Thank you, Judge.
All right, Mr. Garcia, Ms. Garcia, anything else on this case?
No, Judge.
All right. Any other cases for Mr. Garcia?
Not according to my docket, Your Honor.
Do you have any other cases, Mr. Garcia?
No, Your Honor.
It's great to see you, Mr. Garcia. Have a great year.
Thank you, Judge. You too.
Thank you.
I think I have one more for Mrs. Cotto. I'll stand by until it's my turn. Thank you.
Thank you.
Counsel Elisa Mar Soto on page 7, number 18.
Anthony Martinez, Erika Lorenza Reyes, cause number 2025 FLC 518C3. Court marks Ms. Soto, President participating by video conference, Mr. Santos, President participating by video conference. Good afternoon to both.
Good afternoon.
Are you Anthony Martinez? One more time, are you Anthony Martinez? Is this your client, Mr. Santos?
It is, Your Honor.
Court marks Mr. Martinez, President participating by video conference without access to audio.
Testing.
Are you Anthony Martinez?
Yes, Your Honor.
Welcome to court, Mr. Martinez. Court marks you present. You're participating by video conference. As you can see and hear from your device, your lawyer is also present and participating by video conference. Erika Lorenza Reyes, are you present?
She should be on Zoom, Your Honor, and she does need an interpreter. Well, actually, no, Your Honor, I don't see her. That one of the course she had told me that she was going to be signing in.
Court marks Ms. Reyes not present. Mr. Santos, Ms. Soto, what is the announcement?
Your Honor, as a preliminary matter, we would be urging, and we are set for a motion for withdrawal.
I don't have any opposition to that, Your Honor.
So this is Mr. Santos's motion to withdraw. Do you have any pending pretrial motions, Ms. Soto?
I do not, Your Honor, accept the temporary orders that the court had asked us to submit on December 12th, haven't been signed.
Well, that's odd.
Your Honor,
I
our
think the
concern
court
is
had
that
asked myself and Mr. Santos to submit temporary orders because we were going to decide the amount of child support.
Your Honor, and our concern
And
is
we both had different amounts.
that's
Sorry, Mr.
correct.
Santos.
And our concern is that during since our last hearing, various documents have been filed on Mr. Martinez's behalf by Mr. Martinez, and we weren't aware about about any documents being filed. So there hasn't been very much communication, and again, we would urge that motion for withdrawal.
Los que iban a arreglar cosas así.
All right. So I guess let me take these up in the order that we're set for. First thing on the procedurally on the court's radar is the request to withdraw. The movement is Mr. Santos. Any objection, Ms. Soto?
No, Your Honor.
Mr. Martinez, your lawyer is requesting to withdraw from this case. Do you have any response or objection?
No, Your Honor.
All right. The order granting the motion to withdraw is granted. It is signed. Court is tendering the original to the clerk's office. Any other cases for Mr. Santos?
It was just that one, Your Honor.
You don't have any other cases today?
I don't believe so, Your Honor.
Have a great day, Mr. Santos, and have a
Thank you,
great year.
Judge. Thank you, you too. Thank you.
All right, that brings us to the second procedure. Well, two more things. Ms. Flores, does the court have Mr. Martinez's email address?
Yes, Your Honor.
All right. Mr. Martinez, you don't have a lawyer at this hearing. In the future and right now, will you go forward with a lawyer or are you going to represent yourself?
I am right now put a motion for pro sec, Your Honor, but I am requesting a motion for extended time to find counsel or legal aid.
All right. So the court marks you self-represented at this juncture and the court will grant you some time to hire a lawyer. Next question. The amended temporary orders, those are the orders that you are requesting the court to sign, Ms. Soto?
Yes, Your Honor, but the child support amounts were what I proved up in court. Mr. Martinez and Mr. Santos were going to provide the court with their own computation of child support, and then the court was going to decide between those competing orders. I don't think that Mr. Santos ever filed his own document.
That might be why the court hasn't signed, if the court is at that juncture, I guess. So let me hear from you, Mr. Martinez. So Ms. Soto, by her argument here today and by page 5 of her amended temporary orders, she's asking the court to set child support in the amount of $637.50. What response or objection, if any, do you have?
I respond, we have that set to another evident hearing. After going through my bank statements, she has based that income off my W-2 for $46,676.50. While going through my bank statements of 2024, I see here that I got a deposit of $38,826.35 from employer, with per diem deposits of $12,854.04.
Have you submitted this information to the court?
I was trying to file a motion for modified child support, but I also put a motion for Rule 175 statement because I couldn't afford the fees of $80.
And why were you being charged $87?
$80 to submit for modification of child support, because I was under the impression that they already settled on the child support.
I don't know what the source of that misunderstanding could have been or is, because as Ms. Soto has reminded the court, the issue before the court was what was the true and correct amount of child support. And I think it was you and your lawyer's duty and obligation under the court's advisement to submit information necessary for the court to make the adjustment. If there is no information provided, then the court grants what is proven. And in that case, then the amount should be set at $637.50. So I tell you what, I'm going to sign these amended temporary orders. The court has not heard sufficient evidence or testimony or argument in the record to do anything different, but we'll come back for final hearing. You can talk to a lawyer, seek legal counsel, and together with your lawyer, you can prepare for that final hearing so that the court can make any adjustments upwards or downwards or something different at the final hearing. So these are only temporary until you prove otherwise. Does that make sense, Mr. Martinez?
Yes, Your Honor.
All right. Court is tendering the original signed amended temporary orders to the clerk's office. These are now orders of the court. And then we'll come back for a final hearing on the petition to adjudicate parentage on February 24th at 2 p.m.
Your Honor, if I may, I had set some other motions in place that are pending. I don't know if your office has received my motions.
Let me see those motions, Ms. Flores. Let me take them one at a time. We're coming back for a final hearing, so let me ask you these questions, Ms. Soto, because we may be able to cut through procedurally some of these issues, but don't at all feel that I'm asking for any sort of agreement, yes, one way or the other. I just need to know so we know what to expect on February the 24th. So your first motion or your first request is a motion for the appointment of a parenting facilitator. That is your request, Mr. Martinez?
Yes, Your Honor.
Any objection to the court considering that at this time, Ms. Soto?
I do, Your Honor. It was just recently filed. I have not filed a written response, but Mr. Martinez filed an affidavit of indigency. That's the same situation my client's gonna find herself in. She can't afford a psychosocial assessment, a parent facilitator, and any other delays in this case. So we are objecting to all of Mr. Martinez's motions.
I'm gonna take it one at a time. So as to the appointment for parenting facilitator, there is an objection. That matter is set for hearing on February 24th at 2 p.m. at the date of the final. That's the next date we have. You're also requesting the appointment of a neutral child therapist. Any objection to the court considering that at this juncture, Ms. Soto?
There is an objection, Your Honor. I want to have that heard on February 24th at 2 p.m. as well, to give me a chance to respond in writing.
So ordered. There's a motion for the extension of time to seek legal assistance. The court has already granted that by setting this for February the 24th. There is a motion for the extension of time to complete a hair follicle test. What would you like the court to know, Mr. Martinez?
Your Honor, I'm not trying to avoid or not comply with the courts. I just in a financial hardship at the moment that I just couldn't afford to pay to make the deadline.
Ms. Flores, did the Community Supervision Department file something with the court?
Yes, Your Honor.
So at some point, Mr. Martinez, you were tested at the probation office?
Correct, Your Honor.
All right, so I'm gonna read into the record what the probation office has sent. So it's county department to county department, sent directly to the court. Alcohol, excuse me, this is a test dated August 12, 2025. The results for alcohol were negative. The results for amphetamines is positive. Benzoids negative, cannabinoid negative, cocaine negative, opiate negative, and the validity is normal. So based on that, you have one positive drug test. I'm not going to give you an extension because it's your burden, right? If whatever it is you want to do, take the time you need, but you need to have your evidence in by February the 24th to circumvent this now positive drug test. So ordered.
Your Honor, I had submitted a psych evaluation which explains that I take a controlled substance prescribed by my doctor that will come out positive, along that I have prescribed that prescription bottle to probation office to expect that positive result.
All right. Well, just to make sure that you and or your lawyer make that argument on February 24th. All right. I mean, in other words, so I'm not making any decisions based on that. I'm just telling you what it is. And then at the final hearing, the court needs to figure out through evidence and testimony and argument what weight, if any, to give that, and whether there are any other tests or what explanations you have, defenses, all these things. So we'll come back on February the 24th. Anything else for the court to consider, Mr. Martinez?
I had put in a motion to grant roll for 145. If you guys can see the agreement or grant me towards that for inability to afford costs.
But I think that's a matter for the clerk's office to consider, is it not?
Correct, Your Honor.
Right, so I don't make that decision. The clerk's office will take and receive that and then process that. Any other request, Mr. Martinez?
Yes, sir. I had requested an application clarification as far as just only communication between the mother and me. And I had sent to Ms. Soto if that excludes the grandmother, because the grandmother's majority of the time with the child, while Erica works 2 jobs during the day and the night. So if that would violate anything with my temporary orders.
Ron, I didn't receive any such communication and I don't see any such motion filed with the court to clarify that issue.
I don't see it either, Mr. Martinez. So just look, I'm just going to court order you. Just any and all persons involved in this case, parent, caregiver, or otherwise, just communicate respectfully. And if there are any violations of any court orders, just testify to it on February the 24th. Do you have any other requests, Mr. Martinez?
No, Your Honor.
Anything else on this case, Ms. Soto? You're on mute.
Sorry, no, Your Honor.
All right. I look forward to hearing and finalizing this case on February 24th. I wish all persons well. Any other cases for Ms. Soto?
Stay there. Just the one on standby, Your Honor.
All right.
Next online is Council Melissa Saldaña, page 2, number 3.
Veronica Sanchez versus Cristelo Antonio Madrigal, cause number 2013 CVG 2144C3. Court marks Ms. Aldana present and participating by video conference. Mr. Chu present and participating by video conference. Rene Cantu, are you present? Court marks Mr. Cantu not present. Veronica Sanchez, Cristelo Antonio Madrigal. Any other person present?
Yes, Your Honor. I'm present. Cristelo Madrigal.
All right, welcome to court, Mr. Madrigal. The court marks you present. You're participating by video conference. Your lawyer is also present by video conference. Veronica Sanchez, are you present? Court marks Ms. Sanchez not present. Ms. Alani, Mr. Chu, go ahead.
Yes, Your Honor.
Judge, go ahead, Melissa.
Thank you. I received Mr. Chu's revisions after my revisions, and we're in agreement with each other's revisions. So it's been filed by Mr. Chu's office, and our office is in agreement with that final order that was submitted.
Wonderful and fantastic. The court marks Mr. Elias Alcantar present by video conference on behalf of the AG's office. Mr. Alcantar.
Thank you. No objection, Your Honor. Sorry.
Does the clerk have that version?
Your Honor, I believe they're referring to the order that Mr. Chu filed on November 19th. It should be this.
Court has received, reviewed, and considered and signed by agreement the order in suit to modify parent-child relationship filed by Counsel Chu on November the 19th, 2025. It is signed. Anything pending on this case, Ms. Aldana?
Nothing pending, Your Honor.
Mr. Chu?
Nothing pending, Judge. Thank you.
Mr. Alcantar?
No, Your Honor.
You have any questions for the court, Mr. Madrigal? Court has seen no. All right. I wish you all well. Any other cases for any counsel?
I have.
Council Saldaña, page 2, number 4, and Council Chu further down the line.
All right. Jennifer Buenrostro Carlos Longoria, cause number 2013 CVW 1179C3. Court marks Ms. Saldana present and participating by video conference. Philip Del Rio, are you present? Court marks Mr. Del Rio not present. Jennifer Buenrostro Carlos Longoria, are you present? Court finds the parties are not present, and the court finds that Mr. Elias Alcantar is present by video conference on behalf of the AG's office. Ms. Aldana.
Yes, Your Honor. In this case, I've conferred with Mr. Philip Del Rio. He's out of town right now. We are still in the process of working on the final order, including getting the income information so that we can submit that to the OAG so that the child support can be calculated and included in the final order. So basically, we're asking for another date to be able to finalize the final order.
Response or objection, Mr. Alcantar?
No objection, Your Honor.
This is the first setting by court policy, so ordered. Give us another entry of judgment date, Ms. Flores.
Yes, sir. That'll be February the 10th at 2 p.m.
Other cases for Ms. Saldana?
No, Your Honor.
Have a great day, Ms. Saldana. Happy New Year.
Happy New Year.
Thanks.
Next online, Counsel Claudia Lanesa Garcia, standing in for Counsel Madeline Escoto, page 6, number 50.
Veronica Contreras versus Benito Antonio Banda, cause number 2025 FLA 1450C3. Court marks Ms. Claudia Lanesa Garcia present, participating by video conference on behalf of Counsel Escoto. Counsel Ruben Arce, parties Veronica Contreras, Benito Antonio Banda. Is any other person present? Court finds no other persons are present. Ms. Garcia.
Your Honor, Ms. Escoto is asking for a 2-week reset for this matter, please.
This is a trial on the merits. Do you have any thoughts or information as to whether the matter is contested or agreed to?
I don't judge. I'll be honest with you. I don't have information with regard to that. But with her requesting a 2-week reset, I trust that she knows that she's going to get resolution that day. And it's my experience that she's very effective in conferring ahead of time and trying to get resolutions way before the hearing. So I'm confident with that.
Well, I guess to be cautious, Ms. Flores, give us 2 dates. Give us a final pretrial hearing in the very next setting that we have in 2 weeks. And just in case, give us another setting for final hearing, just in case it becomes contested.
Final pretrial will be February the 10th at 2 p.m.
All right.
I'm sorry, February 10th or 12th?
February the 10th at 2 p.m. And final hearing March 31st at 2 p.m.
I don't think that's. I think the court's intent was a final pretrial hearing on January 28th at 9, and then that final hearing February 10th at 2. So let's do that. Final pretrial January 28th at 9, and final hearing February 10th at 2. All right.
February 10th at 2 or 12th?
For this one, you said the 10th. Did you not, Ms. Flores?
Yeah, February the 10th
All right.
would be at 2 p.m.
All right.
Okay.
Any other cases for Ms. Garcia or Mrs. Cotto?
No, Your Honor.
Good to see you, Ms.
Thank you,
Garcia.
Judge.
Have a great day.
Thank
Happy
you,
New Year.
too.
Next online, Counsel Lily Gutierrez, page 6, number 16.
This is Aida Patricia Compian versus Aristeo Compian, cause number 2025 FLB 421C3. Good afternoon, Ms. Gutierrez.
Good afternoon, Your Honor, and Happy New Year.
Likewise, Court Mark Chu present and participating by video conference. Good afternoon, Mr. Chu.
Good afternoon, Judge. Present for Ms. Aida Compian.
Court Mark Chu present and participating by video conference. Are you Aida Compian?
Sí.
We'll begin Spanish language interpretation now. Are you Aida Patricia Compian?
Sí, señor. Señor juez.
¿Es usted Aida Patricia Compian?
Sí, señorita.
Yes.
Aristeo Compian, are you present?
Your Honor, Mr. Compian is my client and he is not present. I filed yesterday an agreed motion for continuance and am urging that this afternoon due to the fact that we received discovery responses from petitioner on the 7th of January, which was last, I believe it's Wednesday, and I need time to review that with my client. I do anticipate a possible agreement. I know that there's been a delay, however, there's been an extension that we've agreed to for petitioner, and that brought her deadline to last week.
May your translation, please.
I apologize.
La señora no está presente, él es mi cliente y ayer yo presenté una petición para una prórroga para que podamos de la fecha que íbamos a estar aquí el día de hoy, debido a que hemos recibido algunas pruebas y hemos pedido desde el día 7 que habíamos pedido desde el día 7 de enero, que creo fue el miércoles, y necesito tiempo para poder revisar con mi cliente. Sí, anticipo que probablemente podamos llegar a un acuerdo y espero que esto no vaya a causar ningún retraso y que se nos puedan otorgar esa extensión.
Mr. Chu?
Yes, Judge, that's our agreement. Ms. Gutierrez has been patiently waiting for us to respond to the discovery, and we have, Judge. So our agreement is to ask the judge for the court for additional time. Thank you.
Sí, juez, en este momento la señora Gutiérrez ha estado muy paciente para que podamos darle esta respuesta en cuanto a las pruebas y de hecho sí estamos de acuerdo en poder pedir esa extensión.
The court hereby grants the request.
Se les va a otorgar esa petición.
By policy of the court, there's now two settings, a final hearing. Ms. Flores?
And how much time, Your Honor?
I'm going to ask you for two hearings, both before March the 12th, 2026.
Mr. Honor, final plea trial will be February.
No. The final hearing? That's the first setting? And the dismissal date?
Ms. Flores not on the record.
No, Ms. Flores. I'm asking for two dates, both of them before March 12, 2026. First date is the final hearing.
The final hearing was March 5th, Your Honor, at 2 p.m. And then you said a dismissal date, Your Honor?
Before March the 12th, 2026.
It was February 24th, Your Honor.
For a final hearing. Right. So final hearing, February 24th at 2 p.m. and the dismissal date, March the 5th at 2 p.m. This should bring this case into compliance with the Texas Supreme Court time standards for family law cases. All right. Any thoughts, comments, questions, or objections to any of this, Ms. Gutierrez?
No,
Muy
Your
bien,
Honor.
en este momento vamos a tener dos fechas finales. La audiencia final va a ser para el día 24 de febrero a las 2 de la tarde y la fecha en la cual este caso va a quedar sobreseído va a ser para el día 5 de marzo a las 2 de la tarde.
Okay.
Ms. Gutierrez.
No, nothing further, Your Honor.
No hay nada más, su señoría.
Mr. Chu.
We have nothing further, Judge.
Nada más por parte del abogado Chu.
Ms. Compian, do you have any questions for the court?
No,
Señora Compián,
No,
¿usted tiene
señor
alguna
juez.
pregunta?
no.
No, Judge.
Ms. Compian, I wish both you and Mr. Compian very well. Have a great day.
Señora Compián, les
Gracias.
deseo lo mejor. Que tengan buen día. Thank you.
Gracias.
Any other cases for either counsel?
No, Your Honor.
It's good to see you both. Have a great year.
Have a great year, Judge. Thank you.
Thank you.
Next online, Counsel Alberto Martinez King, page 4, number 11.
Carlos Misael Gloria versus Wendy and Ai Gloria, cause number 2025 FLA 1213C3. Court marks Mr. Martinez King, present and participating by video conference. Good afternoon, counsel.
Good afternoon, Judge.
Good afternoon, Mr. Villafranca.
Good afternoon, Your Honor.
Court marks you present and participating by video conference. Carlos Gloria, Wendy Gloria, are you present?
Miss Gloria is present in my office.
Court marks Ms. Gloria present, participating by video conference from the Office of Counsel. Carlos Misael Gloria, are you present?
He's not present today, Your Honor.
So noted. Mr. Villafranca, Mr. Martinez King, what is the announcement?
Your Honor, I've spoken to Mr. Martinez King earlier today, Judge. We're pretty close to probably settling this case. We were going to request from the court 30 days. I heard earlier the court gave for another case of the January 28th final pretrial setting and then the February 12th trial on the merits setting. Your Honor, I was going to ask the court if we can get those settings to, give us some time to work this case out, Judge. It looks like we're very close to come to an agreement.
Mr. Martinez King?
That's correct, Judge.
Ms. Flores, give us those settings, please.
January the 28th at 9 a.m. and final hearing February the 12th at 9 a.m.
We should get it resolved before then, Judge. Or we will.
I'm sure your clients and the court would both appreciate that. Mr. Villafranca, Mr. Martinez King, thank you both. Any other cases for either counsel?
Not on us, Judge.
Correct, Your Honor.
All right.
That's
Good
all
to
I
see
have,
you
Your Honor.
both. Have a great 2026.
Thank you, Your Honor. You too. Thank you, Judge.
Page 3, number 7.
This is Danny Nava versus Brittany Marie Salinas Nava, cause number 2024 FLA 1290C3. Speaking to the microphone and tell the court, are you Danny Nava?
Yes, Your Honor.
Welcome to court, Mr. Nava. The court marks you present in person. Are you Brittany Marie Salinas Nava?
Yes, Your Honor.
Welcome to court, Ms. Nava. The court marks you present in person. Mr. Nava, do you have a lawyer?
No, sir.
Are you going forward today without a lawyer?
Yes, sir.
Court marks you self-represented. Does the court have Mr. Nava's email address?
Checking on.
Ms. Nava, do you have a lawyer?
I do not, Your Honor.
Are you going forward today without a lawyer?
That's correct.
Court marks you self-represented. Court marks Mr. Elias Alcantar, present and participating by video conference on behalf of the Office of the Attorney General. Ms. Flores?
No, Your Honor.
Mr. Nava, what is your email address?
It's navalakers86@gmail.com.
One more time, a little bit slower.
navalakers86@gmail.com.
All right, be on the lookout for your email. If the court needs to send you any notices or information, it'll go there. Mr. Alcantar, on behalf of the Attorney General's office, will do the same thing. And so may Ms. Salinas Nava. The court in December allowed Mr. Nava's lawyer to withdraw. This is a divorce with children. Mr. Nava, are you ready to go forward?
Yes, sir.
Ms. Nava, are you ready to go forward?
Yes, sir.
Mr. Alcantar, any objection?
No, Your Honor.
All right, Mr. Nava, Ms. Salinas Nava, let me ask you both to raise your right hands. Do you solemnly swear or affirm that the testimony you will give in this cause will be the truth so help you God?
Yes.
Both have answered yes. You may lower your hand. Sir, is your true and correct name Danny Nava?
Yes, Your Honor.
Mr. Nava, you filed this divorce on August 15, 2024. On that date, had you lived in Texas for 6 months?
That's correct.
And you lived in Webb County for 90 days?
Yes, sir.
Are you currently married?
No, sir.
Is this not a divorce?
Well, yeah. Well, yeah.
You can't be asking for a divorce if you're not married. Are you currently married?
Supposedly we're already divorced. I mean, that was the case where we first came into the court. Yeah. I believe you have granted the divorce.
Is there a final decree of divorce on file?
Runner.
Did the court, Mr. Nava, pronounce and render you divorce?
I believe they did, sir. I mean, I don't recall it very well, but I mean, that was the first case. That was the main reason I came here for the first court for a divorce. So, I mean, if that's the case, no.
I don't know what to make of your answer. Ask the clerk's office to look at the procedural. I'm going to do the same thing and see if there's a final decree of divorce.
Will do, Your Honor. There is no decree on file, Your Honor.
Mr. Nava, I reviewed the procedural history. You're still married.
Okay.
The court has never pronounced and rendered you divorced. So let me begin again. Let me just start all over again. Mr. Nava, Ms. Salinas Nava, raise your right hands. Do you solemnly swear or affirm that the testimony you will give in this cause will be the truth, so help you God?
Yes, sir.
Yes, Your Honor.
You may lower your hands. Now that you're under oath, again, Mr. Nava, is your true and correct name Danny Nava?
Yes, correct.
Mr. Nava, you filed this divorce on August 15, 2024. On that date, had you lived in Texas for 6 months?
That's correct.
Had you lived in Webb County for 90 days?
That's correct.
Are you currently married?
Yes, sir.
To whom?
So Brittany Marie Salinas.
What was the date of your marriage?
It was in January. I don't recall the dates. It was like a very long time ago.
January 5th, 2010.
Does that sound right, Mr. Nava?
That's correct, yes.
When did you stop living together as husband and wife, Mr. Nava?
I'm sorry, can you repeat that again?
When did you stop living together as husband and wife?
The day we got married, living together.
That you stopped living together?
Stopped living together. I believe it was on the date that I filed for the divorce.
On or about August of 2024?
That's correct.
Court takes judicial notice of that date. Mr. Nava, has your marriage to Ms. Salinas Nava become insupportable?
Yes, Your Honor.
Is there any possibility that you reconcile?
No, Your Honor.
Were there any children born in the marriage?
Yes, Your Honor.
How many?
5 kids.
Their ages?
Brianna, my oldest daughter, she's 19. Danny Jr., he's 16, and Courtney Nava, she's 13, and Danielle is 10, and my youngest son Ethan's 9 years old.
So to confirm, you have a 19-year-old adult daughter.
Yeah.
You have a 16-year-old son, a 13-year-old daughter, a 10-year-old daughter, and a 9-year-old son.
That's correct, Your Honor.
All right. Do you have an agreement with Ms. Salinas Nava about child support and visitation?
About child support visitation?
Child support and visitation?
Well, no. I mean, I didn't place child support on her. As she does have visitation. I believe it's every other week. She goes and visits them on Saturday and Sunday.
So let me ask you, do you think it's in their best interest that she not pay child support? Or do you believe it's in their best interest that she pay child support?
I mean, I just the thing is, her, like, I don't want her help. I just want her to help herself.
What about these visitations? You said that under temporary orders, I guess,
Right.
that she visits them every other weekend.
Right. Correct.
And are those visits working?
Yeah, they're working fine.
Do you believe that extending those visits, in other words, for them to continue indefinitely until the court makes another finding, maybe in the future, that should remain in place?
Yes, Your Honor.
Do you believe that that is in your children's best interest?
Yes, Your Honor.
And these children currently live with you, right?
Yes, Your Honor.
How long have they lived with you exclusively?
Since she left, or
I don't know.
oh, and lived for me with me since they were born.
Any community property for the court to divide?
It's just a property that a house that I bought, where my kids are actually living right now.
When did you buy that house?
It was like, I believe, like 2 years ago.
Has Miss Nava ever lived at that home?
Yeah, she did live at the house.
When was the last time she resided there?
The last time where we finally came to the conclusion where she insulted me with there was something in my face, so that's when
When was that?
I was when was that? I believe it was September of 2024.
All right, then what is it that you're asking the court to do with that property?
Okay, sir. So I mean, for me, like, I want to keep the property because that's where my kids live, and that's the only thing I want. Like, I want to keep the property for my kids' house, not to be sold.
Do you believe that would be a just and right division?
Yes, Your Honor.
Is there any other property that the court should divide?
No.
Ms. Nava, you're under oath. You heard Mr. Nava's testimony. Is there anything you want to change, add, or say?
I would like more time with the kids, or, I mean,
for me to take the kids this time because they're under the temporary orders. But there was a confusion there was a court where you said that you weren't gonna hold that against me because the court times were changed and I was never advised.
I'm sorry, say that again.
The court times were changed when the temporary orders were set. And you had mentioned that you weren't gonna hold that against me, that you were the one who changed the dates. So nobody advised me of it.
Oh, sure. So there was a setting and then the court, for whatever reason, needed to move a setting. I guess at some point you didn't know or the court didn't advise.
They didn't.
So the court wasn't going to hold your non-appearance at that hearing against you, sure. But tell the court about your request for more time with your children.
Well, I would like my kids to stay with me. Well, I would want my kids to be with me instead of staying with him.
Your Honor, your microphone is off.
I hit it. Ms. Nava, you want your children to live with you.
Yes,
Do you believe that living with you is in their best interest?
yes.
Tell the court why.
Well, right now, my kids, Wookie works mostly all week. So my kids are under the care of my 19-year-old daughter.
Say that again.
My kids are under the care of my 19-year-old daughter. And it's 4 other kids, so I don't think she should be responsible to be taking care of them.
So you're requesting that your children live with you because during the time that Mr. Nava is at work, your adult child, your 19-year-old, takes care of the others. Any other reasons?
Well, they need a lot of attention, Your Honor. They've been acting up. Well, one of them, the 13-year-old, has been acting up in school, and this caused him to change her school. I've gotten calls from the teachers and the counselors where she's acting up, and it's because there's nobody disciplining her at home. So she's not getting any attention, or I guess she needs someone there to set like authority in the home.
Just trying to follow along procedurally, and I'm pulling up your cases so that I can follow along with the procedural history as you testify. So ostensibly, Ms. Nava, you're requesting that your children live with you, and I guess you believe that somehow that would be better or best in their interest versus living with Mr. Nava. Tell the court, are there any other reasons?
Well, they always called me that they want me to go over, and sometimes I can't because he doesn't want me to, but they're alone. And they need me. They want me there to just cook for them and just spend time with them.
Yeah. All right. Anything else you want to tell the court? Anything else that Mr. Nava said that you disagree with?
No.
Are you requesting a name change at this hearing?
Yes, sir.
To what name?
Brittany Marie Salinas.
All right. Anything else you want to say? Oh, respond to Mr. Nava's request that he keep the house.
No. Or at least, I wanted to divide our property inside the home. As far as like the living room, the washer and dryer, and other stuff that we have inside the house. My kids will be spending time there, so I don't know if, we were barely talking today outside before we came in.
Sure.
And I think we need more time just to settle, to come to an agreement on what exactly is that we're gonna do.
Well, that's the thing. If you don't have an agreement, I get to decide
Oh,
for
well,
you. So, yeah, I'll give you more time if you want to talk. But if you don't have an agreement, I can just make a decision. Mr. Nava, you heard Ms. Salinas Nava's request. She says that the children living with her would be in their best interest because you're at work and during that time, your adult daughter takes care of your children. What response do you have to that?
Yes, Your Honor. Oh, my daughter does help me out with my kids. So does my mother. She's the one who picks them up from school. Like right today, she picked them up. My mom also stays with them. So every time I don't go all week from work. I just go Monday, come back Tuesdays. And I don't believe she's telling the truth. I'm saying that my daughter takes care of them fully. Uh, I would want the court to, if somebody can actually sit down and talk to my kids, if you guys can feel more comfortable with who the kids want to live with, that way you guys can have you guys' own opinion.
Well, this is an eighth setting, and
Right.
that request should have been made. It's a late request now. But Mr. Nava, tell the court how did your children end up in your possession, living with you for this extended period of time, and not with Miss Salinas Nava? How did that happen?
Well, I've been working for the past 10 years, sir. So I mean, I believe I'm the one who actually been paying for other stuff, and I mean, at the end of the day, she hasn't been working for a while, so. I mean, I don't understand why would she think my kids would be better off with her? I mean, I'm the one who.
So my question is, here's a testimony that I've heard from both of you. I've heard that the children live with you. They don't live with mom. They have limited visitation with mom, and there has to be a background, a reason, a basis for that. What is it that happened, Mr. Nava?
Well, it was because of the family violence at the house where she was acting up kind of weird towards me. So she had like a drinking problem. So my kids would tell me that all the time that their mom was sleeping all day while I was at work. So that's what all accumulated to. So I used to go over the road I'm a truck driver. So now I changed jobs for me to be working only Texas routes. So that way I can be more at home. So, yeah.
Ms. Salinas Nava, Mr. Nava advises the court that the genesis, the beginning of your children's stay with Mr. Nava was some sort of incidents at your house. Tell the court about that.
Your Honor, the reason that he has temporary custody right now is that because I missed that first court where the temporary orders were set. That's the reason why, because I didn't show up to court. Or at the time it was.
Do you believe that?
Yes.
Do you have pending criminal charges?
Yes, I do, Your Honor.
Right. Doesn't it make more sense that the court would have made a decision based not solely on your non-appearance in court, but because you have, I'm just taking judicial notice and reviewing the public filings of Webb County. You have one active criminal case and you have another pending. So doesn't it make more sense that the court would have looked at your record and said, maybe this is not the best idea right now?
Judge, I believe I'm innocent until proven guilty, and I think I'm gonna fight those cases.
You're absolutely right. So you're innocent in the criminal case until proven guilty, but here, we're not doing criminal law, we're doing family law, and in family law, this court needs to make an assessment and finding as to what is in your children's best interest. So I'm looking at the documents of this county. You have one pending. It's a criminal trespass. And the pending charge that you have, what type of charge is that?
The assault charge.
Who is the alleged victim in that case?
Chanel.
So tell the court, based on this, how is it in your children's best interest that they reside with you?
Judge, I have never been physically or abusive anything with my kids.
Yeah.
I believe what happened that night was something that never was supposed to happen. My kids, I mean, I raised them, and all my kids were doing good in school. They graduated, and we have academic honors, and that's with me being with them at the home. And now that I'm not at the home, now my 13-year-old is acting up, and they're getting disciplinary actions at school. I mean, there is a notice of a difference without me in the house.
How long have you been out of the house?
Since he put the protective order, from the assault, which was in 2024.
That makes sense based on the timeline that both of you have given the court. So to say that any recent changes that they're attributable to you moving out of the house, you've been out of the house for over a year, have you? Almost a year and 4 months, 5 months.
Excuse me?
You how long you've been out of the house for over a year and 3, 4, 5 months?
Yes.
Hmm.
But I haven't taken my kids sleep, with them.
That
But
I
I
think that's
didn't leave the house. I was forced to leave from the house because of the temporary orders.
oh, I see.
So I didn't leave my kids. I just can't go back because of the temporary orders.
What else do you want to say, if anything?
I just want what's right for the kids. What's in their best interest. The house,
So
if they want
since August of 2024, they have been in Mr. Nava's possession.
that's correct.
Tell the court what changes they would experience, if any, if the court were to modify that at this point. Would there be any changes, no changes, disruption, no disruption? You tell me. What in that scenario, if the court grants your request, what would happen?
I just want what's best for my kids, Your Honor. I just want to give them the attention and what they need so they can be what they're expected to be. I just want them to be good in school and to, if they don't respect us at home, then we can't expect them to respect anybody out in the streets, and they need discipline.
Those are all good requests. Mr. Nava, so you heard the request of Ms. Salinas Nava's urge, but what she's asking is that your children, both of your children, all of your children, go and live with her. What do you think about that idea?
Well, Your Honor, if I can say this, I used to work in the oil fields, all right? So I got a call that she was arrested for smuggling immigrants. So I actually had to quit my job. I was working in Midland. I had to come back all the way to Laredo, and she was arrested like for a year. So like that's in the past. So I don't know if I can bring that up. So
When did that happen? When did the arrest happen for that incident?
it's like
That was like 6, 7 years ago now.
When the youngest was 3. Ms. Nava?
I believe so.
Ms. Nava, did you serve time for that incident?
Yes, Your Honor.
How much time
12
did you
months.
serve? Are you currently on federal probation?
No,
You've
I
completed that?
finished everything, yes.
All right. Mr. Alcantar, do you have any questions for Mr. Nava?
Your Honor, as to custody and visitation, I do not take a position. Generally, though, we would ask that the court order child support. If non-custodial parent pay child support, and that's going to depend on who the court's going to be appointing as the primary conservator. So I believe the court should consider that first before we get into the numbers.
All right. And same response if I ask you. I just need to get through that portion first.
For the mom, yes.
All right. Mr. Nava, Ms. Salinas Nava, anything else that you want to say and put on the record before I make a decision?
I just want the best for my kids as well, sir. Yeah. At the end of the day, the house is just a material.
What's the value on your home, Mr. Nava?
It's 225,000.
And how much is owed?
I believe like 218. No, not all the payments go to the house,
Oh, right.
Yeah.
There's interest. Are you requesting child support, Mr. Nava? Let me ask you this: does Ms. Salinas Nava currently pay child support?
No, Your Honor. She hasn't been paying it for the since we started this court, like for a year and a half.
All right. Anything else that anybody would like to say before the court makes a decision?
No, Your Honor.
Mr. Nava, Ms. Salinas Nava, in your case, cause number 2024 FLA 1290C3, the court at this time finds that it has jurisdiction over this case, meaning this is the proper court form and venue to consider your divorce. The court finds that you entered into marriage on the 5th day of January 2010, but you stopped living together as husband and wife on or about August of 2024. The court at this time finds that your marriage has become insupportable due to a discord or a conflict of personalities that destroys the legitimate ends of the marriage relationship. The court finds that there were 5 children born in the marriage. No other children were born, adopted, or are expected. The court finds that your oldest daughter is now an adult, leaving 4 minor children of the marriage. The court hereby appoints both of you as joint managing conservators, which means that both of you have the same rights, duties, responsibilities, and obligations over your children, except that you, Mr. Nava, are given the exclusive right to determine their residence. The court finds that doing this is in the children's best interest. You have had that right since at least 2024, and the court takes Ms. Salinas Nava's previous and current criminal history into consideration. But the court is going to grant you extended standard visitation, Ms. Nava, and that's the full the court can give under Texas law. The court finds that doing this is in the children's best interest. The court finds that there's only a house to divide. The court finds that there really isn't much equity in the home, and this is the home where the children reside. So the court finds that a just and right division is to award Mr. Nava the home, including all debt. Court finds that this is a just and right division given these circumstances. Before I make a decision on child support and health insurance, Mr. Alcantara, do you have any questions for Ms. Salinas Nava?
Yes, Your Honor, just a couple.
Go ahead.
Ms. Salinas, what kind of health coverage do the children have?
They have Medicaid.
And are you currently working?
Yes, yes, sir.
And about how much do you earn?
Like well, for 100 a week.
That before or after taxes?
After taxes.
Do you know about how much it is before?
Well,
let me ask this if I can. Are you hourly?
No.
Your salary. What is it? And how much is it per month? About?
Per month?
Yes, however you get paid.
I would say 1,300.
Okay. Pass the witness, Your Honor. I'm sorry, Your Honor. And Ms. Salinas, do you have any other children besides the children of Mr. Nava?
No, sir.
Pass the witness again, Your Honor.
Mr. Nava, do you have any questions for Ms. Salinas Nava?
No, Your Honor.
Ms. Salinas Nava, do you have any questions for Mr. Nava?
No, Your Honor.
Mr. Alcantara?
Yes, Your Honor. Child support based on the $1,300 as testified to by the mom would be at $400 for 4 children, and medical at $57. This is guideline amounts.
Ms. Salinas Nava, so the Office of the Attorney General tells the court that you could and should be ordered to pay $400 per month in child support and $57 in medical insurance. What do you have to say? Respond or object?
That's fine.
Say that again.
That's fine.
Final or that's fine?
It's okay.
I understand. Mr. Nava, you heard the request by the Attorney General's office. What would say you?
I mean, I agree, sir.
All right. The court hereby orders child support in the amount of $400 per month beginning February 1st, 2026 and continuing until these children age out. There'll be step-down provisions. Medical support is hereby ordered in the amount of $57 per month, also beginning on February 1st, 2026. At this time, Mr. Nava and Ms. Salinas Nava. Oh, one more thing. Ms. Salinas Nava, the court hereby changes your name to Brittany Marie Salinas. And at this time, Mr. Nava and Ms. Salinas, the court finds that there is no reasonable expectation of reconciliation, and the court hereby renders and pronounces you divorced. These are the orders of the court, and the orders are due honor before
January the 26th at noon by submission.
Let's do that. And you know what, Ms. Flores, give us an entry date on a self-represented docket date.
That'll be February the 4th at 2 p.m.
We'll come back to court on February the 4th so that I can sign your orders. Do you have any questions for the court, Ms. Salinas?
No, Your Honor.
Do you have any questions for the court, Mr. Nava?
Yes, sir. I just have a question. As far as when you say she's gonna have a more extended time to visit the kids, what are those days gonna be?
First, third, and fifth weekends, Fridays through
Is
Sunday.
it gonna be ready? I'm sorry.
Yes, it'll be in first, third, and fifth weekends of the month and Thursdays as well.
Okay, thank you.
A Thursday, like a dinner visit. Right. Do you have any other questions, Mr. Nava?
No, Your Honor. Happy New Year.
Mr. Nava, Ms. Salinas, I wish you both well. More importantly, I wish your kids all the best.
Thank you.
Page 4, number 9.
Cesar Eduardo Trejo versus January Gonzalez, cause number 2025 FLA 731C3. Mario Castillo Jr., are you present? Court finds Mr. Castillo Jr. not present. Cesar Eduardo Trejo, are you present? Court finds petitioner Trejo not present. Are you January Gonzalez?
Yes, Your Honor.
Welcome to court, Ms. Gonzalez. Court marks you present in person. There is a motion for continuance.
Again.
Ms. Gonzalez, have you had an opportunity to review the motion for continuance?
Oh, well, yes, but it's the second time he asked for a continuance. And he has never shown up, so.
But have you seen this one?
Yeah, he says he has a son, but I think he's a lawyer, right?
He has a son that's a lawyer and he has another son that isn't a lawyer.
Yeah, I know, but
Right.
the son is the lawyer's son, like the one is in the hospital.
No. No. So let me, oh, I apologize. Mr. Alcantara, the court marks you present.
Thank you, Your Honor.
Participating by video conference. So let me just tell you what, on the record what the motion says. This is a filing by Mr. Castillo. The petitioner's attorney's son was involved in a horrific vehicular accident and was flown to San Antonio, Texas. And he has been in San Antonio since the date of the accident. For that reason, he's requesting additional time. So we're set for dismissal today, because you're right, we've been here multiple times. We're set for dismissal. And at this setting, what the court needs to determine whether there is any good cause, reason, or basis to grant any other time. So what this lawyer has filed is this request. Ms. Gonzalez, do you agree, disagree? Do you object? What is your position?
It's up to you, but my husband, soon to be ex, is working and he's not making time to come to court. So he's not even present in video conference,
Right.
and he's the one asking for the divorce.
No, I don't disagree with that. What position, if any, does the AG's office have, Mr. Alcantara?
Your Honor, we do not take a position. I do not take a position at this time.
Yeah.
No objection.
So we're set for dismissal, Ms. Gonzalez, and if the court finds good reason, cause, or basis, then I have to keep it on. And I don't think anybody, no, I don't think, I know nobody plans for these things to happen. If a child of any person is in a terrible vehicular accident, you drop what you're doing,
So
you understand the
Yes.
situation. It's the golden rule that applies here, right? Give us another setting in 45 days, Ms. Flores.
That'll be March 5th at 2 p.m.
Does the court have Ms. Gonzalez's email address?
Yes, Your Honor.
Do you have any questions for the court?
no, you're.
I wish you well. Have a great
Happy
day.
New Year.
Thank you. Likewise.
Bye.
I have nothing further, Your Honor, if I may be excused.
Have a great 2026, Mr. Alcantara. Good to see you.
Thank you, Your Honor. You too.
The cases that are left to call are the ones on recall, Your Honor.
Well, let me get some announcements on the recalls, and if there are any agreements, I'll take them up. If not, we will pause momentarily Page 5, case 12, Adrian Garza versus Karim Berastegui, cause number 2025 FLA 1412C3. Court marks Mr. Del Barrio present in person, Mr. Ferreira present in person, Mr. Garza present in person, Ms. Berastegui present in person. Counsel, what is the announcement?
Your Honor, I believe we have an agreement with regards to I believe Brava's motion for an ad litem. We have an agreed order for that. There's no agreement as to an ad litem. I will leave that up to the court's discretion.
Interesting. Because you're not asking for continuance, you agreed to an ad litem, but because by policy of the court, since this is the first setting, you get it anyway, so.
Yeah.
Interesting result, Mr. Pereira.
That's correct, Your Honor. I filed a motion, then filed an agreed order with the rights and duties of the attorney ad litem. Request for a report to be submitted 10 days before final. And I just want to add that my client is represented by legal aid. There's a statement of inability filed with the legal aid certificate. And we're requesting that the fees that would be assessed to her as cost would be covered by the county, I think it's county court or commissioner's court.
Sort of, but not necessarily. First question to the clerk's office. Is there a statement of inability to pay?
Yes, Your Honor.
So just a couple of notations. I mean, so the statements are this is a private case, right? If it were a criminal case, or if this were an enforcement case where one party is asking for enforcement, then the court could order the appointment of counsel and other things, but this is a private civil legal matter. 1, 2, the fees that the court could waive are those that are due to the government. Private legal matters, for example, if one person or the other has a legal obligation to pay a private individual, the court really has no say as to waiving those fees. So I guess first question, Mr. Ferreira, is there any person that you and Mr. Del Barrio agreed to appoint?
No, Your Honor, we were going to ask the court to appoint one from the wheel. Did you have some comments on Rule 145, if I may? So under Rule 145, it's court-appointed professionals. And there's case law that states that items, psychological analysis counseling constitutes a court-appointed professional. I've even had court cases where the court has paid for examination, polygraph examination, and has been covered under Rule 145 as a court-appointed professional, as long as there's an order from the court appointing that said person.
You are referring to Rule 145?
Yes, Your Honor.
And what did you, on behalf of Ms. Berastegui, file?
We filed the statement of inability when I filed the counter petition for this case. It's prima facie evidence of the inability to pay court costs. It's uncontested, and that should be sufficient for the court to designate her as indigent for court costs. And again, court-appointed professionals are considered court costs under 145.
And Your Honor, if I may, I know I've had that issue come up in other courts, and it actually just came up in the 111th, and I know Judge Knotson had an issue with it because although I've seen it happen, I've also seen it where the ad litem not get paid and it becomes an issue. And I know that's been an issue with certain ad litems not wanting to take on new cases, but I don't know if the court has I mean, my client also does not have, excess funds to be paying, but obviously I did make him aware that the court would probably require an ad litem in this case, as there's no agreement as to the custody. But if we can get possibly an ad litem that the court is aware, or if we can speak to a few that will not charge an exorbitant amount of fees as well, because I know there's a few out there that their initial payment is almost like a retainer for some attorneys as well. So I don't.
But the motion, the agreed to motion, let me see.
As far as for the motion, is that my part of the agreement, Your Honor, is that I'm agreeing to for an ad litem to be appointed. There's no agreement as to whether she should pay or not. That's leave that up to the court.
Yeah, I don't have my motion in front of me. I have the agreed order, but on the motion, I did include the subsections of 145. I can provide the court with a brief of case law. Or the court needs it.
Let's get this, Mr. Ferreira. So I'm looking at the requirements under the rule you cited, but the motion, so that's step 2, but step 1 is the request for an ad litem. What argument do you have in support of the appointment?
Well, Your Honor, the appointment of the ad litem would resolve many, if not all, the issues of this case.
But the court can resolve those issues without the ad litem, could it not?
Yes, Your Honor. There's a little bit of background. There are 3 children in this case, a 12-year-old and I believe it's a 5 and a 4. Petitioner and I have spoken, counsel has spoken, and we believe it's in the best interest if there's the item is appointed so that they can speak to the children directly, get the full the full understanding of what the children want. That would benefit a lot instead of just listening to parents.
He said versus she said.
Yeah, it would benefit if there's somebody to listen to the children and provide.
So I understand the benefit, but I guess I'm asking about the legal requirement. Is it discretionary on the court once the request is made? I mean, it isn't at this point because you're set for final hearing, and so this is a late request. But assuming that the court allows it, and assuming this was timely, and it's not, is the appointment mandatory or discretionary?
It'd be discretionary, Your Honor.
So I tell you what, before I approve the agreement and before we even venture down that road, I tell you what, before we even get there, why don't both of you have conversations with both Mr. Montemayor and Mr. Hernandez to see what possible financial arrangements can be made, and the court will exercise its discretion based on your conversations. So I may or may not do it, but at least you have some thought, and your clients will have some knowledge about what fees can be. And then you come back and see if the court grants its discretionary authority to grant or not grant. All right, so stand by. Robert William Slaughter versus Mexico Moving Company LLC, Reina Madrigal Martinez, clause number 2023 CVI 1507C3. Court marks Ms. Soto, President participating by video conference. Mr. Juan Hernandez, President in person. Robert Slaughter is present also by video conference. Reina Madrigal Martinez, Brett Green are not present. Ms. Soto, this is your request. Are you ready to go forward? Ms. Soto?
Yes, I am, Your Honor. Can you hear me?
Yes, Mr. Hernandez, are you ready to go forward?
Yes, sure.
All right, Ms. Soto, this is your request. Go ahead.
Yes. So, Your Honor, we had filed a motion for sanctions that the court has already heard. At the end of that session, the court did rule that the defendant, Mexico Moving Company, would be responsible for paying for mediation fees for the mediation that had to be rescheduled or that the court ordered to resume. The court left any other sanctions and attorney's fees pending. And my associate attorney did tell me that the court wanted to hear any information regarding attorney's fees expended, which I did supplement with my motion to reconsider. And I also wanted to add the email string that I added as further evidence, because my understanding is at that initial hearing and in the Mexico Moving responses to my motion to reconsider, they're still alleging that the failure to attend both the informal settlement conference and the mediation that was agreed to by the parties were a calendaring error. And I don't believe that at least the second instance was a calendaring error. I think that was the Mexico Moving Company representing to the court that they wanted to reschedule their motion for a summary judgment hearing so that they could go to mediation. We agreed to reset the motion for summary judgment hearing, followed up with Judge Hale, who's our mediator, to schedule that mediation. And at about 4:30 p.m. the day before we were scheduled to go to the mediation, that mediation was unilaterally canceled, stating Mexico Moving Company had no money to pay attorney's fees and no money to pay any type of settlement or mediator fees. So we don't think it was a calendaring error, and we think that that financial issue that Mexico Moving Company is having was pretty evident, or should have been evident, to Mexico Moving Company before they even requested a rescheduling of the motion for summary judgment and rescheduling that mediation. My client has already paid me, Your Honor. He paid me in excess of $3,000 to prepare for the informal, attend the informal. We were waiting for Mr. Hernandez and Mexico Moving Company to show up. We incurred additional fees to come to court again for that motion for summary judgment hearing, where they asked us to agree to a mediation. We prepared a position paper. We communicated with Judge Hale's office, and of course conferred with our client to prepare him for that mediation and that informal settlement conference. All of that is detailed in my affidavit, and that is the new evidence that I wanted the court to consider. Currently, Your Honor, there's 3 parties to this lawsuit. All 3 parties are attending that mediation. Initially, we had asked the Judge Hale to do a half-day mediation, which fee is $850 per party. Now, considering that there's 3 parties involved, I don't think a half-a-day mediation is going to suffice. I do think we need a full-day mediation, which of course drives up the cost of that mediation. So we would ask the court to grant us the attorney's fees that I've submitted in my affidavit. And in the alternative, if the court does not want to grant any additional funds, for sanctions, that it should be a full day mediation. And it's instead of $850, the Mexico moving company should pay the entire daily fee, which is $1,850 for our side to attend mediation.
I guess let me hear a response before I comment.
Your Honor, first and foremost, the same issues that she brings today are the same issues that she brought before. And there were the same issues that Miss, I forget her name, Judge, her associate. And Your Honor, I wish I was infallible, but I am not. People make mistakes. And in this case, we have not tried to, I guess, to hide the ball, to not go and to, I guess, consciously and callously and all of those good things, to disobey an order. Judge, it was a mistake. I brought it up to the court. And the court cannot give something that it did not give before. I think the court says, look, people make mistakes. You know, the sanctions that I believe I had was I would pay the mediation fees. And I'm willing to do that. Now, insofar as a motion for sanctions, Judge, you know, this is an extraordinary remedy. It's not something that the court is going to give only because someone says that you either made a mistake or you couldn't have done it, or they didn't show up, or they weren't ready and we objected to any reset of the case. I have always been very amenable to resetting the cases and all of those things, Judge, which is just proper etiquette. Now, if the consideration is there, the court doesn't need to look at a consideration. There's no discoverable, there's no evidence that was discovered that wasn't brought in before the court. There wasn't any error of law. There wasn't any manifest injustice. And that's where we're coming from. Now, from the purely the standpoint, Judge, you need to kind of look at it from the outside looking in. They filed a motion for breach of contract against the moving company. His name wasn't even appearing in the contract. They've had to amend it 4 times, and they may amend it another time. But you know, Mr. Ponton is from Alabama. Okay? So from his standpoint, is like, you know, I don't know why I don't even know why I'm in this case. And so we filed our motion for not for motion for continuance, but our motion for summary judgment. But to me, Judge, the easiest thing right now is that if they could have or should have filed an affidavit for attorney's fees, they should have done it in the first place. And if they didn't do it in the first place, Judge, I mean, they can appeal it if that's what they want to do. But the fact of the matter is, as we prepare for trial and or for mediation, Mr. Ponton is basically flabbergasted. What is it that they're trying to do to me? Number one, they sue me under the wrong theory. We tell them we had nothing.
I'm going to object to that being outside and a sidebar for my client does not have to be listening to any sidebar comments. We're arguing the motion for sanctions, not what he thinks the merits of the case are.
All right, sustain, but let's go forward. Go ahead, Mr. Hernandez.
So Judge, I mean, I think that the court does not need to make any further findings, does not need to grant anything else. Let us go into mediation. Maybe we can resolve it there.
Anything else, Ms. Soto?
Yes, Your Honor. So my understanding of that last hearing is the court did reserve the right to consider attorney's fees if further evidence was presented. That's why we're presenting the affidavit of attorney's fees. And we may not be able to conclusively prove to the court why that mediation was canceled, but we think that it was Mexico Moving Company's position to try to amend their motion for summary judgment and obtain a reset on a summary judgment that was a one-page document. That's why they asked for that mediation and that for that summary judgment hearing to be reset. With knowing that there was no intention of going forward with that mediation. Meanwhile, my client's expending fees and preparing for that. So we do respectfully request that the court, as I mentioned before, that the court grant us the attorney's fees, and in the alternative, if the court's not inclined to grant additional fees, then the mediation cost should be for a full day mediation and not a half day. We're not going to finish a three-party mediation in half a day.
Well, Judge, I mean, if thinking that something is going to happen, then they probably should have looked at the contract and know that my client wasn't on it.
Your Honor, we have an agency and the other party has represented that Mr. Hernandez's client was paid for his services, so he is involved and he is absolutely has liability exposure in this case.
Took you for motion.
All right, folks. So this is what the court's going to do in this case, cause number 2023 CVI 1507C3. 4 or 5 points. First point, the court is going to affirm its intent at the first hearing, and that is that a full mediation take place. And either I said it on the record or I thought it, because what normally happens at morning mediations, if the mediator decides halfway through that there is sufficient progress to warrant continuation, then just finish it out by continuing the rest of the day, and you can come back and tell the court we're done. But either I said that on the record or I thought it. So either I'm affirming what I did or should have done at that hearing, or I hereby grant the reconsideration and will order that full day if necessary, and if Judge Hale thinks that there is sufficient progress being made. Number one, of course, those costs are assessed to Mexico Moving Company, LLC. Now, that's to Ms. Soto's point, to Mr. Hernandez's point. Well, I agree with that. So the court made 0 findings of intent, perhaps fault, but not intent. There's no malice that the court found. The court did find that it was likely a mistake, right? So I mean, bad that it happened, but not bad by intent, at least none that could be proven. But because of that mistake, and that's what the court was trying to note on the record at the previous juncture, it was that mistake, unfortunately, that has us here, right? It's that mistake that the court isn't listening to Mr. Montemayor's case right now or Mr. Del Barrio's case right now. And it's not just the court and the parties and the lawyers, but also it's also the court coordinator, the court clerk, the court bailiff, the other security officer, and so forth, right? So there are costs associated with mistakes, but the court doesn't find that fault or malice or any bad dealings resulted in that. It's just a mistake, and to rectify that, right? The court finds that this is a just and right outcome in this case. The court abates any and all further decision on this specific matter until the final hearing date on March 17th at 2. And the reason the court does that in the interest of justice. Doing anything different is going to put one or both bad taste in each of your positions before you even get to mediation. And I need you all to go willingly, voluntarily, and fully participating. I could do this now, but I would like for the parties to have the best shot at full and final settlement. Frankly, looking at it from all the perspectives, the payment of a full day mediation is not only good, right, and just, but as a business and practical standpoint, 1 day mediation is going to be a whole heck of a lot less than any other cost that could be associated with. So the court finds that this is good, right, and just, so ordered. Ms. Soto, Mr. Hernandez, do the parties already have a mediation date scheduled?
January 26th, Your Honor, starting at 8:45, and it's currently set for a full day mediation for all three parties.
I certainly wish all parties well at mediation. Go participate in good faith and come back and tell the court on February the 3rd if mediation was successful or not. Anything else on this case, Ms. Soto?
No, Your Honor.
Mr. Hernandez?
No, Your Honor.
Mr. Slaughter, do you have any questions for the court?
No, Your Honor.
All right. I wish you and all the parties well at mediation. Good luck.
Thank you.
Thank you.
Ms. Soto, Ms. Hernandez, always good to see you. Have a great 2026.
Thank you, Your Honor.
Moving on to case 3. Julio Cesar Villasaña, Joanne Elizabeth Rangel, cause number 2024, FLC 1931C3. Court marks Mr. Montemayor present in person. Julio Cesar Villasaña present in person and Joanna Elizabeth Rangel present by video conference. Mr. Montemayor.
Not on the record.
Your Honor, we are already prepared. I believe, but the Barrio was going to.
I do have an announcement, Your Honor, if possible. We did confer with Mr. Montemayor at the court.
All right. Let me take up that announcement. That is page 5, case 12. Adrian Garza, Karim Berasi, cause number 2025 FLA 1412C3. Court marks Mr. Del Barrio present in person, Mr. Ferreira present in person. Both parties, Mr. Garza and Ms. Verasti present in person. Mr. Del Barrio, Mr. Ferreira, go ahead.
Your Honor, I believe we have an agreement, in speaking with Mr. Ferreira, and Mr. Montemayor, we've agreed to have Mr. Montemayor serve as the ad litem, in the case. He's also agreed to a total cost of $750, graciously agreed to that, which is actually a good deal for both parties, Your Honor. I believe, in speaking with them, with Mr. Ferreira, I believe his client should be able to come up with half of that.
Mr. Ferreira.
That's correct, Your Honor.
The court has considered the
And based on that, Your Honor, we are asking for a reset of the final hearing.
court hereby approves the agreement. court finds that there is an agreement for the appointment of Mr. Montemayor. And the court finds that there is agreement between the parties and Mr. Montemayor for the payment of $750 for his services. It is so ordered. The court has tendered the original signed document to the clerk's office. I guess let me begin by asking you, Mr. Montemayor, how much time would be reasonable and necessary to prepare, get up to speed?
Judge, when I conferred with the attorneys, I'm thinking of, 30 days, so they can just send me their pleadings, and any narrative, that they want me to consider, and I'll be more than glad to do it, but I think you can, get it taken care of right.
Your response, Mr. Pereira?
Your Honor, that's fine. 30.
Mr.
I'm okay with that time frame.
All right, give us on or about 30 days, Ms. Flores.
Yes, Your Honor, that'll be February the 12th at 9 a.m.
All right, Ms. Garza, we'll see you here on February the 12th. Do you have any questions for the court?
No, I do not, Your Honor.
Excuse me, Ms. Verástegui, do you have any questions? Apologize. Mr. Garza, do you have any questions?
I can,
I was wondering why you were looking at me funny. I got your name wrong. I apologize for that. We will see you here on February the 12th. Keep in contact with your lawyers and keep in contact with Mr. Montemayor. Good luck to all.
Thank you, Judge.
That leaves one case, Julio Cesar Villasaña, Joanne Elizabeth Rangel, cause number 2024 FLC 1931C3. I tell you what, we've been going on since 2. Let me hear some opening statements. We'll take a very short break and then we will immediately go into evidence and testimony. Mr. Montemayor, opening statement, what your client is asking and how he thinks he can prove it.
Your Honor, we're asking the court to appoint my client as the petitioner in this case as the managing conservator to determine the primary residency of the child Juliet in this case. We believe it'll be in her best interest. We asked the court to consider issues like stability of the home, the conduct of the respondent when she left the home, the significant period of time that she failed to respond to requests for information. She has failed to return calls. She, disappeared for about 23 days and failed to return the child to the homestead where the child has resided since 2022. Even now, she has blocked Mr. Villasaña from any communication during her visits. When she's supposed to be there at 6, she gets there at 7. And it's, the child now has developed what we believe, while in her custody, panic disorders, anxiety disorders, and is displaying this conduct that is concerning, and we would like a doctor to verify that before we turn the child over for any visitation. So we're asking that we believe that at least temporarily, it's in the best interest of the child that she continue to reside with my client. My client has a stable employment with the Texas Department of Corrections. He has, he has his mother there who can help supervise and has family support. She, can attend the local schools here, and I believe the child may feel better at the end of the day and thrive as a child while under his care and custody.
A couple of questions, Mr. Montemayor. You're right. I see it in my notes now. We're set for final hearing, but we're also set for temporary orders. But the request you're making today is not permanent. It's just temporary until we get to final.
Well, Your Honor, we filed a motion for emergency orders because we were trying to, the temporary orders that we had in place only went through 2020. I think it was through the summer of 2025. We didn't have anything in place for Thanksgiving. We didn't have anything in place for Christmas holidays or the New Year holidays. And so we attempted, many times. I did it, my staff did it, to contact Mr. Parra, who was her attorney, Ms. Rangel's attorney at the time. And they lost complete, well, we were informed that they had lost complete communication with her. Very similar to what we've gone through as parents. And so we were not able to get anything. So I didn't want to wait anymore. So I filed the emergency motion. hoping we can at least approach the court and get some visitation for.
I recall the procedural history now, Mr. Montemayor, under the terms of the now expired temporary orders, who, if anyone, had the exclusive right to designate the residents?
Neither party did, Your Honor. We were just working off of the visitation order. You know, the child had been enrolled in school over there without our knowledge. And
So assuming I ask Ms. Frankel right now if there's an agreement, and assuming she says there isn't, is Mr. Villasana requesting temporary orders or a final decision?
we'd like to, I mean, if we're going to do this, Your Honor, we'd like to go, you know, for a final hearing. The only thing I have, Your Honor, to add to that is that we now have this looming medical appointment with the doctor tomorrow. And those documents have uploaded into the Thomson-Reuters evidence file. And so that's the only reason I'd ask for a temporary order, so we can at least get this cleared up before we move into a final hearing, give the court that information, because I think it's pertinent to you know, her safety and her health.
But do you think that there is any possible diagnosis that this medical professional could give that would change the court's decision as to conservatorship?
I believe it is. I believe it is material for the court to consider. I think it's important that the child's health and safety. The child is 5 now, and so I believe, you know, even a conversation in chambers with Your Honor might even be in order here. Now that's not.
But what type of medical professional is this person?
Your Honor, the documents that we submitted were from the Novelty Behavioral Health, which is located on McPherson here in Laredo County.
And I think that's the court's point. So if and when this child gets evaluated by a medical professional at this behavioral professional's office, is it really possible that that person gives any diagnosis that allows the court to say that Mr. Villasana or Ms. Rangel is better suited to be named as the managing conservator?
I've never had a medical professional testify as to the ultimate issue.
Right.
But I do think that you know, given the circumstances of where the child has been, the fact that we've had no access to her, and now the child is acting out, you know, and I think that is very, very relevant to.
Sure. Mr. Rangel, you heard the request made by Mr. Villasana regarding your child. What is it that you're requesting the court?
Yes, Your Honor. I'm requesting for Juliet to come back. She has lived primarily within the past year under my care. And for the prior 4 years, she has been constantly in my care since birth. Juliet's school friends and community are located in San Antonio. She attends school, daily participates in extracurricular activities, and has no history of behavioral or academic problems. I have pictures of, Your Honor, of Juliet attending field trips, after school events, and her during school hours. I consulted Juliet's teachers and school counselors regarding this concern, and they reported no signs of anxiety, behavior issues, or academic concerns, and describe her as happy, healthy, and excited about becoming a big sister. I do have a written statement sent via email from Ms. Seremo, Juliet's kinder team leader and reading internist.
All right.
I would
Mr.
like to respectfully request the court. I'm sorry, Your Honor.
Go ahead. You would like to request the court
Yes.
what?
The court order Juliet's immediate return, restore stability on her education, and seek her medical care needed here in San Antonio without the need to miss any more days of school, and issue orders that promote cooperation, communication, and Juliet's best interest.
See, I heard one thing from Mr. Montemayor, now I'm hearing something else from you. So let me just get clarity. And these I'm just going to ask some questions that should, just be factual and agreed to. So, Mr. Rangel, one child between you and Mr. Villasana?
Yes, Your Honor.
A 5-year-old?
Yes, Your Honor.
Daughter?
Yes, Your Honor.
Now, I heard Mr. Montemayor make one request that the child stay with Mr. Villashana, but then I heard from you that she attends school in San Antonio. So where does your daughter live
Yes.
today?
Today, as of today, she is with Mr. Villasana. He hasn't returned her since the Christmas holidays. That's when she left and she didn't came back after that.
All right, anything to disagree with those set of facts, Mr. Montemayor? One 5-year-old daughter had been residing with Ms. Rangel, now since Christmas residing with Mr. Villasana?
Correct.
All right. The factual background has been properly framed and presented to the court. The court will start hearing evidence momentarily. We will stand at ease for a few minutes. Good afternoon. Court is back in session. This is the family law docket for Tuesday, January 13th, 2026. The time is now 5:19. Court is once more in session. This is cause number 2024 FLC 1931C3 Villasaña versus Rangel. Present in person on Mr. Montemayor and his client, Mr. Villasaña. Present via video conference is Ms. Joanna Rangel. All right. Let's begin. Mr. Montemayor, who is your first witness?
I'll call Julio Villasana to stand.
All right, Mr. Villasana, step in front of the microphone first. And let's have our court coordinator start the witness stand video. Mr. Villasana, would you raise your right hand? Do you solemnly swear or affirm that the testimony you will give in this cause will be the truth, so help you God? Court is heard, yes. You may have a seat here on the witness stand. And give us a second while we set that device up. Speaking to the microphone, Mr. Villasana.
It's on.
Speaking to it.
It's on.
All right. Mr. Montemayor and Ms. Rangel are going to be asking you some questions. Pause for a second before you answer. Make sure you respond with yeses and nos. If you say, it won't be captured on the record. Speak as loudly as you can. Do you have any questions?
No, sir.
Mr. Montemayor?
Thank you, Your Honor. You are Julio Cesar Villasana?
Yes.
And you are the petitioner in this case. Is that correct?
Yes.
You are the father of Juliet Mandy Villasana?
Yes.
Correct. And the mother, Juliet's mother is Joanna Elizabeth Rangel?
Yes.
So you and Joanna lived together for how long?
A year and a half, more or less.
At what address?
6115 Monaguillo Drive.
And before that, did y'all buy that house together?
Yes. She's primary, I was co-buyer.
Y'all lived together at that house. And before that, did y'all live together with Juliet?
Yes, we were in an apartment.
Okay, what apartment was it?
I recall the name.
You were there were you there when Juliet was born?
Yes.
And were you there when she took her first steps and
always been present?
Yeah. And so you helped bathe her and care for her and feed her?
Correct.
And so y'all lived together at this other address. Y'all bought a house together. And Joanna up and left, is that correct?
Yes.
Okay. What day did she leave?
She left on November 2024.
In November of 2024. And do you know where she went?
She had said that she was going with her mom.
Where's that to?
In San Antonio.
Did she tell you? Did she plan this out? Did she tell you why she was leaving?
No, it was just the weekend.
And she was leaving for the weekend, but she never came back, correct?
Mm-hmm. When she came.
Yes or no?
Yes.
Okay. Go ahead. You were saying something?
When she came back, she was supposed to come on Saturday because that's what she had said. Same thing. The night has passed by. Same thing for Sunday. She came Monday to drop off my daughter for school. When she gets to the house, she basically told me that everything was over.
Okay.
And left.
Your daughter was going to school here in Laredo?
Yes, she was going at Freedom Elementary.
What grade was she in?
She was in pre-K.
How long has she been attending Freedom?
I want to say like 3 to 4 months, 3 months more or less.
And how old was your daughter when she started pre-K?
4.5.
4.5?
Yeah.
So for her 4.5 years, you were with Juliet every day, and suddenly Joanna took Juliet with her and left San Antonio.
Yes,
Did you know where she was going?
she had mentioned only her mom. No address was given.
Did she tell you why she was leaving?
Nope.
Is it for employment purposes?
She had said she wanted a better opportunity and leave, I guess make some money with her mom.
All right. So did you come to find out where she moved into?
No. Another person had told me where the address was.
Okay, well, let me ask you this. Who is Brian Alvarez?
Brian Alvarez was the previous boyfriend of hers. And I guess
This is the gentleman that, is it true that this is the gentleman that she had been seeing while she was seeing you?
yes.
And she left with Brian to San Antonio?
She was staying with her mom.
Okay. And who lived at that house where her mom stayed?
Her mom, her young siblings, her mom's husband, and other men. I guess they were like co-workers from her mom's husband.
So basically, she left to San Antonio in November of 2024. She didn't tell you where she was going. She didn't tell you who she was going to live with. She didn't tell you how long she was going to be gone, correct?
Correct. She has mentioned she was going with her mom.
Okay. And so, did you ever come to find out through Brian Alvarez that she was living in a house with her mother?
Yes.
Okay. Her mother's boyfriend,
Mhm.
her sister,
Mhm.
correct? Got to say yes or no.
Yes,
Her
yes,
sister's boyfriend,
yes.
other siblings were living in the same house,
It was just two siblings, two younger siblings.
and a whole bunch of other
Men.
men. And who were these men that were in this house?
I guess there were her mom's husband's co-workers, friends. I don't know.
So you had different men coming in the house.
Right.
And so who would take care of Juliet when Joanna wasn't there? Did you ever come to find out any of that information?
Yes, I was told by Brian that whenever they will go out or whatnot, his family would take care of Juliet without Juliet knowing who they are.
Was there ever any concern for Juliet's safety there
No,
in San Antonio?
no.
There was. Did you ever have any concern for Juliet?
Oh, yes, yes.
Why?
Because first of all, I didn't know where she lived. I was given the address by Brian. I did open a Child Protective Services case, and she did like try to tell Brian what to say or what not to say. And I did it because Juliet once told me that she slept in the same bed with the other man and her mom.
So in December of 2024, you filed a petition to establish your parental rights. Is that correct?
Yes.
And it wasn't until this petition was filed that you actually got information about where she was staying, who she was staying with, that you were able to finally see your daughter, correct?
Yes.
Before that, was Ms. Rangel cooperative?
No.
Would she answer you in her communications, about your daughter?
Yes, she will, but she wouldn't let me communicate with her or FaceTime or anything with my daughter.
Would she let you talk on the phone with her?
No.
What would she tell you how she was doing?
To wait for court. She made it seem like she already had opened a court case or something.
And she had no.
She had nothing.
She told the court when she first came here that she had gotten a job at HEB in San Antonio.
Or a promotion, something like that, like for better. Yeah.
Was that true?
No.
She hadn't gotten a job at HEB, correct?
No.
She lied to the court about why she had gone over there.
Yes.
And she basically just up and moved out and, didn't really care about anything else, right?
Yes.
In fact, you sold a house that you lived at that y'all bought together, And she never even bothered to, you know, pay any of the debt that she owed. She never bothered to pay any of the
No,
you know, of the mortgage or the insurance or anything like that, correct?
yes, correct. And in order for the house to sell, I ended up paying 5,239 with 45 cents.
All right, so it's been 2 years, Mr. Villasana, since this, well, it's been over a year since this petition has been filed. And have you visited with Juliet?
Yes.
How would you describe those visits?
Short. She would cry at night. I didn't really get to enjoy her as much due to the fact that when we had the Rule 11 agreement, if it had to be, we had to be there at 6 p.m. She'll be there 45, an hour and a half late.
How many times? All the time? Or?
Most of the time.
And when you were going to return the child,
she was on time.
And would she tell you anything about you being on time?
No.
So she cut short your visitation.
Yes.
Okay. And that, you know, how would your daughter act though when she was with you?
When she was going with her?
When she was with you.
When she was with me? Well, she was excited to be with me. Happy.
And how do you see her? How did you see her over the last year? Is she healthy?
I see her skinnier, behavior change.
So you think, was she eating properly?
No, I don't think so.
Did she lose substantial amount of weight?
Yes.
How many pounds did she lose? If you know, if you don't know, don't guess.
I don't know.
Okay. Was she acting out any particular way?
Yes, in the night she would struggle to sleep.
You said she'd cry at night?
Yeah, she would cry.
Why would she cry at night?
I don't know where, scared.
How would she react when you were going to return her to her mother?
Same thing. She would cry, start kicking. She wouldn't.
Did she ever tell you why? Did she ever tell you if there was anything inappropriate being done when she was with her mother?
She fears her mother and also Joanna's partner, husband.
Why do you think she fears Joanna?
She's I guess she don't put the attention needed, and she had said that her husband will hit her.
Who's that? Who's her husband? Joanna's husband?
Joanna's his husband.
And so did she indicate that she was afraid of going back with that?
Yes.
Do you know where Joanna lives now?
I do not.
Have you asked her where she lives now?
I have asked her.
And what has she responded?
No answer. She won't give me the address.
When did she tell you that she had been enrolled in school?
She did once I made the petition and starting
But before that, she wouldn't communicate with you about what school she attended, correct?
She did tell me afterwards.
After the petition was filed.
Yes.
But before that, she never told you where. Did she ever tell you? Oh, let me ask you this.
She did mention the name. I recall. I don't.
She never told you what medical doctors she took Juliet to, correct?
Correct.
She never told you the name of the school that she was going to enroll Juliet until after the petition was filed.
Correct.
Does she let you FaceTime now with Juliet?
There's been moments where I do struggle to get contact with my daughter whenever she had her.
And when you do talk to her, does Juliet show signs of being supervised or?
Yes. If a question has been asked, she gives the stare not directly to the camera, but I assume to her mother.
So her mother's basically watching her as she does her FaceTime.
Right.
Okay. All right. Um. What kind of communication do you have with her mother now? Is it, you, y'all talk or at all?
It's just regarding to my daughter.
Is it every day? Is it, once a week, twice a week?
I guess like every other day.
Does she,
Once
respond? Does she respond to you?
it takes time,
She doesn't respond immediately to you?
not immediately.
Okay. All right. So what do you do for a living?
I work for Texas Department of Criminal Justice as a correctional officer for 6 years and 3 months already.
Do you have stable income?
Yes, I do.
How much do you?
Right now, before Texas,
Yeah, what's your gross amount?
monthly it's like 5,000 and something. I don't have the exact numbers.
And you have Juliet on your health insurance, correct?
She's on the Health Select Blue Cross Blue Shield.
Okay. And what school does Juliet attend with?
Right now she's in Prada Elementary.
In Prada Elementary.
Yes.
Okay. And what program is she? She first grader, second grader?
She's in kinder.
She's in kinder. And you enrolled her.
So she won't fall behind in school.
And that's because you think that there is, or is that because you think that there is an instability there with Joanne?
Yes.
Why do you think there's an instability there with you?
I mean, my daughter does great in any school. She likes school, but I just don't feel she has the proper care for her.
Why is that?
Well, sometimes when I have picked her up. I mean, sometimes she comes to me barefooted. It's been twice that she hasn't had underwears.
Or what do you mean? It's been twice that she has not been wearing.
Whenever I pick her up,
Pick her up your
I always try to have my mom. If I don't have a chance, my mom will pick her up, and she returns her with only the pants, no underwear underneath her.
What else?
Lack of hygiene. I mean, she sometimes comes back smelling really bad, and I ask my daughter if she takes bath, if she showers, and she's her response is that every other day or every 2 or 3 days, which is wrong to me.
Okay, so you think that because there's a hygiene problem, sometimes he's not wearing proper clothing,
Mhm.
Underwear, and she's a 5-year-old.
She's a 5-year-old kid.
5-year-old, correct?
Mhm.
You testified that she's lost weight. And have you done anything about that?
Well, when I had her for the Christmas vacation, I did took her with Dr. Norberto Alvarez because of that, because of the weight loss. And he automatically like questioned my daughter, and he knew something was off.
Don't speculate on what Dr. Alvarez knew, but
Yeah.
But what did he tell you about your what questions did he ask?
If she's eating or how is she doing?
Did he tell you anything about? Did you come to learn anything about his findings?
I guess what he saw into Juliet was she would do a lot of hand movements, and he said it's possible of anxiety.
So what did he tell you?
Oh, he got Juliet referred to a psychiatrist.
And why do you think, in your opinion, why does Juliet have those anxiety, those nervous, and
Well, since I've been having Juliet with me, she really is scared of being alone. And that's something, I mean, she will tell me like, it's because they make me sleep by myself. And I guess that's a fear. or I don't know what she's seeing at Joanna's household right now. I mean, it could be anything at this point.
So you've asked the court to award you or name you the party to determine the primary residency. Do you think you can provide a stable home environment for Juliet?
Yes.
Do you think with you, her health, safety, and welfare are going to be protected?
Yes.
Can you provide better hygiene and better medical care for her?
Yes.
We've talked about the visitation. Is there any issue with Joanna visiting?
No.
Do you think that all these things that you testified to, she doesn't sleep at night, she cries at night, she's lost weight, she has a nervous hand gestures that the doctors may think she's got some type of anxiety, and have referred her to a psychiatrist. You don't think all these things would continue under Joanna's care? If even with the visitation, you don't think they'd continue?
It might continue because she does say she fears her. She fears her.
If the court were to award you even temporary custody, you think that would be in Juliet's best interest?
To be with me, yes.
You think that with you, that it would, well, let me ask you this way. Do you think that if the court allowed Juliet to continue with Joanna, that would endanger her physical health?
And mentally as well.
You think it would endanger her emotional welfare?
Yes.
And do you think that with you, Joanna or Juliet would have a more stable family?
Yes.
You think you could protect the safety of Juliet?
Yes.
You think you could protect her well-being?
Yes.
What about drugs? Mr. Viasana, do you know if Joanna's ever used or abused narcotics?
No.
You know if Joanna suffered from any emotional trauma or anything like that?
No.
So causing just up and leaving, after a child is 4.5 years old, just up and leaving from one day to the next, to San Antonio with no job, no plans, to go live in a house with, her mother's boyfriend, her sister's boyfriend, all these other siblings, and all these other construction men coming in and out of the house. What kind of stable life is that, in your opinion?
To me, it isn't, because first of all, my daughter won't have a bed or a room of her own. She did mention that she will see sometimes the guys walk shirtless around the house, which to me it's a big concern.
When she first left, it took 23 days before her mother actually told you where she was at. Correct?
The one who told me where she lived was Brian.
So, but
It wasn't
mother had
it.
told you found out 23 days later where she was at.
Yeah,
And if Brian hadn't told you, you wouldn't have found out.
I wouldn't find out.
Were y'all in an abusive relationship?
Not really. No,
Have you ever been arrested for anything?
never been arrested.
Have you been accused of anything?
No,
Any police reports ever filed against you for any domestic violence or anything like that?
no,
What about Joanna? Anything that you know of her being involved in any domestic disputes or anything like that?
no.
Only what your daughter tells you that she's.
Well, my daughter says yes.
witnessed her husband hit her. Uh, and so for the last year, your visitations have been, what, once a month? Or once every other 2 weeks?
Once every other week, yeah.
And out of the 24 visits that you had in this last year, how many times was Joanna late? How many times was she late?
I'll say a good 80% of it,
So probably what about?
most of the time.
Most of the time she's late.
Hmm.
And this last time this last Thanksgiving, did she stop communicating with you about Juliet?
There was days I would try to communicate, send her text, and yes, no response.
Did you try to work out an agreement with her with regards to Thanksgiving and Christmas holiday visits?
Yes, but she refused to.
She didn't respond to you.
Mhm.
So it wasn't until when that you actually were able to pick up Juliet?
I picked her up on December 23rd.
And how did that visitation happen?
I went and picked her up all the way to San Antonio
Why is that?
because those were her conditions. And to me, like, as long as I get to have my daughter and see her, why not? I did.
And since then you kept her,
Yes,
and you kept her why?
I kept her because I fear for my daughter's safety, and all because I took her to the medical consultant, Norberto Alvarez.
And that's why you've decided
I decided to keep her.
to keep her until the court made a decision.
Yes.
Then I'll pass the witness.
Ms. Rangel, do you have any questions for Mr. Villasana?
Yes, Your Honor.
Go ahead.
For the scheduled visitation for Thanksgiving, the proposal I made for you, did you deny it?
What's that? Can you repeat yourself again?
For the proposal of visitation for Thanksgiving, did you deny it?
No.
I had sent you a proposal of visitation for Thanksgiving via app close. Do you remember?
It's been asked and answered. He said no, he didn't deny it.
So Stan, you can ask something
Oh,
else
okay.
or move on. It's up to you.
For December's visitation, do you remember agreeing to picking her up on the 23rd and returning her on the 28th via app close?
Yes, I did.
And as far as you not knowing why I left from one day to another, is that true?
Yes.
And as far as Juliet being sent to you barefoot, do you recall me asking you if you wanted her to go barefoot or for me to stop because she forgot to put her shoes on?
I recall.
Mm. And you not being aware of Juliet's um pediatrician here in San Antonio? I never mentioned to you what pediatric she was going to.
You mentioned when she was sick. I don't know. You've never given me information.
Okay. And then do you recall doing multiple welfare checks on Juliet?
I did when you lived with your mom. I don't know where you live right now.
And you mentioned not informing you about Juliet's schools, correct?
I was only given the name of the school.
Um, I think those are it, Your Honor. I'm done. Thank you.
Anything on redirect?
No, Your Honor.
Right, Mr. Villasana, you may step down. Mr. Montemayor, do you have any other witnesses?
I'll call, Joanna Rangel.
Mr. Rangel, would you raise your right hand?
Yes, Your
Do
Honor.
you solemnly swear or affirm that the testimony you will give in this cause will be the truth, so help you God?
Yes, Your Honor.
You may lower your hand, Mr. Montemayor. Go ahead.
Mr. Rangel, I'm gonna ask you a few questions that require basically a yes or no answer. Do you understand?
Yes.
Okay. So you left Laredo, Webb County, in November of 2024. Is that correct?
Yes.
And you had been in a relationship with Mr. Villasana that produced one child, and that is Juliet Mandy Villasana, correct?
Yes.
And when you left with Juliet, who was already enrolled in school here at Freedom Elementary. Is that correct?
Yes.
Right. And so you had lived in an apartment, and you were living at the time in a house that you and Mr. Villasana bought together.
Yes.
You were married?
No. Oh, right now?
No, were you married at the time with Mr. Villasana when you left?
No.
Okay. Did you intend to get married at any time?
He had proposed. Oh, it's a yes or no vote, but in that time, yes.
And so y'all were living together, you had a child, you intended to get married at some time in the future. Did you ever file for divorce if you were considered common law married? No?
No.
Okay. So when Juliet was here, she was in a stable home environment with you and Mr. Villasana, correct?
No.
You don't think she was in a home environment? In a stable home environment?
For the last couple months, no.
Okay. So then you decided to up and leave. You didn't have a job, correct? In San Antonio?
Not in San Antonio, in Laredo, yes.
Yeah. When you left to San Antonio, you didn't have a job. You were gonna stay with your mother who had, a bunch of other people in their home, correct?
No.
You had your mother's husband had construction workers, strangers in and out of the house, correct?
No.
And then you take Juliet there to live with y'all. Juliet didn't have her own room, correct? At that house?
We did have our own room, yes, in that house.
So you had all these strangers and you exposed your daughter to God knows what situations may have come about, correct?
No,
You didn't talk to Mr. Villasana for about 23 days, and it wasn't until Brian Alvarez told him where you were at. Is that true or not true?
I did talk to Villasana, Mr. Villasana, via WhatsApp on December 2024.
In December, after this petition was filed, but you had left in November, Ms. Rangel,
He did had access to her when I was still in Laredo.
but you were living in San Antonio, ma'am. Oh, that's right. You had
No,
up,
yes.
got up and left, and you went to live. I'm sorry, go ahead, finish your answer.
Yes, on November when I left, he still had visitations with Juliet. I even took her to our previous home, to drop her off before I left. He got to see her.
Okay. Was this before or after you were living, you left the house and went to live with Brian Alvarez and his mother?
No, this was before. This was when we had recently not seen each other, split up from each other. I had recently left.
Where do you live? What's your address now?
My current address?
Where do you live now? It's not a trick question. Where do you reside? Where do you sleep? Where do you park your cars at night? Where do you live now?
It's 4903 War Horse Drive.
How do you
Zip code
spell
78242.
workhorse?
War Horse Drive 78242.
And how do you spell workhorse drive?
War Horse. It's WAR.
Okay, I'm sorry.
And it's
Go ahead.
horse HORSE.
And who do you live with right now?
Right now it's my husband and I.
What's your husband's name?
It's Gilberto Perez.
So is it true or not true that Mr. Perez is a convicted felon, ma'am?
No, it's not true.
Is it true or not true that Mr. Perez has served time for criminal offenses?
It's not true.
It's not true?
Wait, criminal offenses?
Yes, ma'am. Criminal crimes. He's been arrested before.
Oh, yes.
Okay. And is it true that he's served time or done jail time? He's been in jail before.
Yes.
Thank you. Do you know what those were? Those offenses for drugs?
No.
Were they assaultive offenses?
No.
Were they for DWI or theft?
No.
What were they for, ma'am? Or do you not know?
Yes. I believe it was. I don't recall right now at the moment. I'm sorry, but
Okay.
I don't know the actual name of it. Yes.
Okay. So are you interested in Juliet having a stable home environment?
Yes, Your Honor. I'm sorry. Yes.
And would you agree with me that Julio can provide a home, correct? Correct?
His working schedule will be a little bit.
Well, but do you agree with me that
Yes.
he can provide a home? Yes. Do you believe that she'll be attending school like she's attending now, correct?
Yes.
Do you believe that Julio has the family support with his mother there, correct?
Yes.
Yes. Do you believe that she has, she'd have the proper medical care under Julio's supervision? Yes?
Yes.
You don't think there's no doubt that Julio will provide care for her in, in his, when Juliet is in his custody, correct?
I'm sorry, can you repeat the question?
You don't worry about Juliet's care when she's with Julio, correct?
I do, but
Let me ask
um,
you, this, Miss Rangel. Are you aware that your daughter has cried at night about fears about returning to your custody? Are you aware?
I'm aware she's afraid of sleeping at night by herself since she has her own room and we've been trying to let her sleep by herself. Um,
Are you aware that she's indicated that she doesn't shower but every 2 to 3 days when she's with you?
she does shower here, I'm sorry.
Okay. Are you aware that even the doctors here have talked about her maybe having panic disorders or some type of an anxiety? Are you aware of that?
Mr. Villasana sent me the medical form where she was diagnosed or evaluated.
Are you aware that the doctors fear that she's lost weight?
I'm not aware of that. She's constantly growing. She's 5 years old. It's common for her to lose weight at that age.
It is? It's common for her to lose weight at that age?
Not that much of a weight, but as far as I've known, the last time I took her to the doctor, she was in 39 pounds for 5 years old. It was on her range for her age.
Hmm. Do you travel, man? Do you have a car?
I do have a car.
Okay. Is it your car or is it the family car or is it just your car?
It's my car, yes.
Okay. And if the court were to award custody to Mr. Villasana, you'd be able to come to Dilley just like he was going to Dilley to pick up and drop off your child, correct?
I'm currently pregnant, so my traveling time, I don't drive a lot anymore due to my pregnancy, but
How many months are you pregnant?
um 30 weeks.
30
That's
weeks,
7 months, yes.
7 months. All right. Is that why you were late to drop off your daughter at the visitation in Dilley? You were sometimes 45 minutes, an hour late, cutting into Mr. Villasana's quality time with his daughter. Is that why you were late? Or is there
Yes, I'm sorry, yes. Yes,
that's why because you're pregnant?
yes, my morning sickness during the pregnancy, it's been throughout the days. I can't really control it. So there was times where I had to stop and take a little break.
Dilley's about an hour from San Antonio.
It's an hour and 30 minutes.
Do you work, man?
Currently I stay at home mom.
Okay.
I'm currently not working.
What does your husband do for a living?
He's a Google Fiber technician.
Okay. Does he have any children? Any other children live with you in your house?
No,
It's just you and him and Juliet.
yes,
How old are you, Miss Rangel?
25 years old.
Tell me why on several occasions Juliet would show up barefooted to the visitation.
Yes, one of those times, we were in a hurry and I told her to get in the truck, as she did. She got in the truck and everything. And as we were driving, or I was driving over there to drop her off, she tells me, "Mommy, I forgot my shoes," and I was already running a little bit late. So I texted Mr. Villasana and I let him know. I was like, "Hey, I know I'm already late, but I can stop by Walmart and get her some shoes, or do you want me to just drop her off like that?" And that's when he told me, he was like, "No, just bring her like that. It's okay." And that's why she went over there barefoot.
Is that the only pair of shoes she took? I mean, she's going away for a weekend. You didn't pack a bag for her
No, we don't usually pack anything. We just she gets out from school at 3:45, and then while I get her, no, I'm sorry, she gets out from school at 3:50. That's her dismissal bell. And then while I'm there waiting online and everything, it gives me 4:10, 4:20 sometimes. And then we came home. She leaves her backpack in her room. She changes real quick her uniform, and then she comes downstairs and we just take off.
I mean, this is something that's planned. I mean, this doesn't just pop up on a Friday afternoon and say, "Hey, we're gonna go down to Dilly." You know, these things are planned. You know, I would think that as a stay-at-home mom, you have the time to gather her belongings, to make sure that she has all the essentials that she needs. And that doesn't seem to be the case, does it?
Yeah, when this happened, that's when I was working. That's why I was running a little bit on a rush.
So you were too busy.
Yeah.
You were too busy
When all of this happened.
Okay. So you were too busy to make sure she had everything she needed.
When she told me, she notified me. Yes, I didn't notice. I just asked her to get in the truck. I booked with her, and I didn't notice.
Okay, well, let's move on to the lack of underwear. For a 5-year-old, you think that that's appropriate?
No.
So why does she show up on numerous occasions with no underwear?
I believe it just happened once, and that's when she came from school. She took a shower, and I always leave her clothes ready for her whenever she takes a shower, and she showers by herself. She's 5 years old. I do go in and check on her, but that day she took a quick shower. She didn't put her underwears, and I didn't notice until Julio notified me about it. And when I went to the restroom, I noticed that she didn't put her underwears. They were there in the next to the sink. When I did ask her about it, I was like, "Hey, what happened? Why didn't you put your underwears?" And she told me, "Oh, I forgot." And I was like, "Okay, but don't do it because Daddy's gonna be mad at you next time."
You don't have good communication with Mr. Villasana, correct?
No, there's a lack of communication there.
You make it sound like y'all have this really nice relationship and y'all communicate all the time, but in reality, y'all stop liking each other, and there's not a lot of communication. Is that accurate to say?
Yeah, I try co-parenting with him on multiple occasions, but there's no sign of him wanting to try and cooperate with me, so I just stopped. I don't try anymore.
And when you say cooperate, does that mean that you basically get to impose your conditions? And if he complies with your conditions, then that's cooperation. If he doesn't comply with your conditions, then it doesn't work.
No, I mean it like when coming to communicate about our daughter, he always seems to um be mad at something, and he doesn't like um for Juliet to call my current husband like stepdad, and he starts fighting or talking about or time sharing her in front of her daughter. So I just don't like that in front of her daughter, because I think that's adult conflict that we shouldn't be making in front of her.
So if Juliet were to say that she's seen your husband abuse you, would that be truthful or would that be a lie?
Of my husband abusing me?
Yeah, that he's hit you.
Oh, no, that would be a lie. Yes.
So Juliet would be lying. Okay. All right. So do you think your daughter should visit with these physicians that have concerns about her panic disorders and anxiety?
I'm sorry, can you repeat the question?
You think your daughter should visit with these physicians that want to talk to her about her panic disorder and possible anxiety situation?
I would like for her to see a psychologist first instead of a psychiatrist due to her being 5 years old. And if then they do say that she needs a psychiatrist, because I know that there's a difference between a psychologist and a psychiatrist. A psychiatrist, it's therapy and medication, and a psychologist, it's just therapy first. So I would like for us to agree in her having a psychologist first, and then maybe if she needs to be referred to a psychiatrist, then we can do that. But due to her age, I would like to be a psychologist first.
Okay. So would you agree then that if Mr. Villasana is granted custody of Juliet, would you agree to pay half the medical costs of those fees for the psychiatrist or the psychologist, whoever's available?
I did talk to her medical insurance here in San Antonio, and she does qualify for the psychiatrist. She is under Medicaid with me, so they can cover for that. We
You
can
have
seek her
Medicaid?
medical,
But Ms. Rangel, Mr. Villasana is providing Blue Cross Blue Shield. Why are you under Medicaid with Juliet? I'm sorry.
I believe in the first quarter, I was able to put her in under. He was gonna put her in insurance, and I was gonna put her in insurance. We were both gonna have insurances for her.
It's up. That's what it's no further.
Ms. Rangel, this is your opportunity to say your story, anything that you want the court to know. This is your opportunity.
Yes. Okay. So I respectfully deny the allegations that are being made against me. I've been Juliet's primary caregiver since the day she was born. Julio's working schedule wouldn't allow him to be there all the time. I have constantly met all of her physical, emotional, medical, and educational needs. She's a healthy, well cared for, and thriving thriving. I'm sorry. Um, Julio has made multiple welfare checks, and CPS reports have been made against me. Every allegation was investigated and ruled out. No findings of neglect, abuse, or endangerment were ever made. Law enforcement and CPS have both confirmed that Juliet is safe in my care. I have never interfered with Juliet's relationship with her father. I encourage a healthy relationship between them and have consistently offered visitation and communication. I believe Juliet deserves both parents in her life. The allegations being made do not reflect my parenting and my history or the facts. They appear to arise from conflict between adults, not from any risk for Juliet, Your Honor. I'm a fit, capable, and loving mother. My focus has always been and remains in Juliet's best interest, her stability, and her emotional well-being. I respectfully ask the court to consider the evidence, investigations that clear me, and Juliet's continued success in my care. The reason why I left Mr. Villasana that he's not aware of, it was because he cheated back in. I didn't find out in the cheating until October. By October, I found out about the cheating. He was cheating on me with the correction officer, Jessica. By November, we tried things out, didn't work. He started being aggressive towards me, so I decided to leave. And I wouldn't provide my information to him because um the person that encouraged me to leave Laredo was actually a law enforcement officer. When he saw me how bad I was, because I did made a police report of that incident, I didn't press charges on him or nothing like that because he's the father of my daughter, and I knew that would affect their relationship. Um, but from from November, he did see her. December, he also got to see her in December. This is not the first time that he tries to take her away from me. It also happened back in November, where he wouldn't want to release her to me again after I had dropped her off at 6115 Monaguillo Drive. I have the CPS investigation. I have the welfare checks. Everything was ruled out, like I said. I am concerned on Juliet's behavioral change. He never reached out to me about it. I tried to constantly talk to him about it, but he wouldn't. Also, Julio has spoken negativity about me to Juliet. Juliet has reported these statements to me on multiple occasions. I have the recordings of 3 separated instances. I have never spoken negatively about her father to her, and instant encourage her to ignore such comments. She's only 5 years old and should not be placed in the middle of adult conflicts. Julio has made parenting decisions without consulting me. He's saying that I am doing the same to him, but it just goes back and forth, to be honest, Your Honor. Parenting time decisions should be made by adults and not childs, because he constantly makes her believe that she's responsible for choosing between parents, and she's only 5 years old. I don't consider myself a high conflict parent. I'm willing to cooperate and work towards a healthy co-parenting relationship. I believe Juliet's best interest is to have both parents involved and not just one parent. One parent suddenly removed from her life, just like he did to me. And she's been here. Since she's been with me, she's been good in school. Her academic, I have her grades in school. She's a very smart child. She knows right from wrong. And he was still seeing her every first, third, and fifth weekend in Daly, Texas. That's where we would do the exchanges.
Anything else that you want to tell the court?
On January 5th, I traveled to Laredo to Julio's residence to pick up Juliet, so she could return her to school. I informed him that I will bring her back for her medical appointment on January 14th, which is tomorrow, for her psychiatrist appointment. And he denied my request and refused to allow me to take her, stating that Juliet fears me. When I asked Julio to see her daughter, he initially denied. After contacting the Laredo Police Department, I was allowed to see Juliet briefly through the gated fence. But Julio still refused to release her. I have the police report number of that incident, and Juliet was visibly happy and excited to see me during that encounter. I have the photos and the video from that day that proves she didn't show any signs of fear towards me.
Understood. Anything else?
On November 26th, I did offer him Thanksgiving visitation. This allegation is false, Your Honor. I proposed holiday visitation through the app close co-parenting application on November 25. I have the screenshots where I offer him to pick up in San Antonio November 26th through the 30th, and Julio declined this arrangement and refused to pick up Juliet in San Antonio. However, he did exercise his regular scheduled weekend visitation by picking her up the day after Thanksgiving in Dili as usual. And for the Christmas holiday, Julio and I agree via app close that he would pick up Juliet on December 23rd and return her on the 28th. On December 27th, when I contacted him to coordinate her return, he became evasive and denied agreeing to return her on December 28th, despite having picked her up on the 23rd pursuant to our agreement. He has not returned it to me since that day. And despite the fact that she wasn't evaluated to January 2nd by Dr. Norberto Alvarez, a family medicine physician. And I can provide with the screenshot of that too, of December 23rd, on him agreeing for his pickup on December 23rd. And Juliet's still, she's still currently enrolled in IDEA just because they know of the situation. So they're holding her seat there in school still. But it all depends. After this court, I'll inform them. On January 7th, without informing me, Julio contacted Juliet's school in San Antonio and requested that for her to be withdrawn. And they're prepared to release her after this court, like I said. But as of today, Juliet continues to be marked absent at IDEA of Breckenridge. He's been aware ever since I moved here to San Antonio what school she goes to. The calendars of the schools. I've sent all that information via Apples. And even her uniform guidelines, since IDEA has uniform guidelines, he's aware of that too. And also, I am currently married, and I do have a stable home to provide for Juliet. She's currently expecting a baby sister. She's excited for that her family is growing. I am concerned for her that behavioral change that she has made. But like I said, we can also seek her medical attention needed here in San Antonio. And I did my research and I have a list of psychiatrists that can make her an appointment for her to seek that medical care that she needs.
Anything else, Mr. Montemayor?
Your Honor, so, look, Your Honor, I would advise my client that, couples split up all the time. And sometimes couples end up in different cities, in different towns, different states. This is not an uncommon situation. But what's key here, it's shady. It's shady on behalf of Ms. Rangel, and it's been shady since day one. My communication with her has always been, very sketchy, and ultimately the last 2 months, even her attorney could not find her, could not communicate with her, and filed a motion indicating just that his communication was not effective anymore with his client and asked to be withdrawn and let go from the case. He could not properly represent her. And that's the same situation we have with her all the time. Talking about making decisions, adult decisions, when there's a child involved, the family code is very clear. It's in the best interest of the child that both parents be involved. And when you up and leave for 23 days and you disappear and end up in San Antonio because, you apparently wanted a better opportunity, and then you testify to this court in a temporary order hearing that, oh yes, I was working, I had a job, a promotion at HEB, and that turns out to be false. And it's just a pattern it's the pattern that Ms. Rangel displays that we're concerned about. She lives in a home, she ends up in a home in San Antonio with her mother's boyfriend, her sister's boyfriend, all the other siblings of all the other children of these people there, and these strange construction men, coming in and out of the house. She was living with Brian Alvarez. She sits here and she says, she points to Mr. Rangel and said, well, he cheated on me. She left with another guy to San Antonio, a guy by the name of Brian Alvarez. He was living with her. And that's the guy who came back and reported to Mr. Villasana about what was going on at the house. And that was the first cause of concern. So, she leaves. The child had been here, Laredo, was born here. She had a relationship with her father. She was going to school. And all of a sudden that's ripped out. Yeah, there's cause for concern. When we tried to establish visitation, it was very sketchy. It was very difficult to get in. And I was glad that she had an attorney because finally we were able to work something out. Communication with Joanna has been tough for Mr. Villasana. He's got concerns about her hygiene. You know, she's showering every day. The child indicated to him that, you know, she showers every 2 or 3 days. You know, she shows up to the visitation without any underwear. She shows up without any shoes. She's got a loss of weight. You know, we've taken her to the physician to get checked because of all this, and now she is displaying signs of some type of disorder, some type of anxiety, some type of panic, and and it's the primary care person has been her mother. And you're right, there have been welfare checks there because we don't have any information. Even just to get her address right now, it was like, it was very shady. It was difficult to get that address from her. She has never released it before to my client. She's living with a convicted felon. She's living with a gentleman who's been in and out of jail, Humberto Perez. So those are all concerns that we have. Mr. Villasana has testified that he can provide care, in custody of the child. He can protect her physical health, her emotional welfare, and he feels it's in the best interest of the child that the child remain with him. There's health issues here, Your Honor. There's safety issues here, Your Honor. There's welfare issues here. And, Mr. Villasana is asking for the custody. He's asking in the alternative that an ad litem be appointed and that we at least get a temporary order so we can at least filter out all these medical concerns that this child may have, and you can grant them a temporary custody and grant Ms. Rangel the visitation in Dili, just like he was doing. And that at the if it's a huge deal because she is a stay-at-home mom, and we were willing to forego any child support until a final hearing can be had. But that's in the alternative. So we ask that the court award Mr. Villasana his legal.
Final word, Ms. Rangel. Anything else?
Yes, regarding about my mom's house, there was no strangers there. It was my mom's house. It's her, my sister Victoria, my brother David, and my mom's husband. There was no strangers there in the house, or living there either. We had our own room, me and Juliet. It was upstairs. CPS checked the room and everything when they went to do their investigation. And regarding saying that I left for a job over here, yes, I did have the promotion. Yes, I did have the interview with HEB, but they weren't willing to match my pay. So I decided to resign from HEB, and that's when I started working as a blue collar worker for a splicer technician. I was a 1099 worker there. And also reminding you the fact, Your Honor, the reason why I didn't want to give my address was because I left Julio because he was being aggressive towards me already, and I'm just not. I don't want any problems or anything. Our daughter Juliet has mentioned to me that he doesn't like whenever she talks about her stepdad over there. So I just don't want any type of conflicts. So that's why it's not because I don't want him to see her. I do take her to Dili for the regular visitation and everything. It's just for me to prevent any more problems. I did attempt to reach to his attorney and left my contact information with the front desk receptionist on January the 9th, but no one returned my call. He has my email too. He can communicate to me via email or phone number, but there's been no sign of his attorney trying to contact me either. Or Julio, we do talk via Aptos. He's been very evasive lately. From January 8th through January 10th, Julio stopped responding my messages on Aptos. I've been calling Julia via WhatsApp. That's where I've been communicating with her, but even today when I texted him about Juliet, if she was out from school, he didn't answer. And I wasn't aware of Juliet's school until now. When I tried to reach out to his attorney and to him about Juliet's school, they wouldn't provide me with that information.
We didn't speak to them. Not because we didn't want to.
All right, Mr. Villasana, Ms. Rangel, in your case, cause number 2024 FLC 1931C3. The board has now heard both of your testimony. Both of you are under oath. Excuse me. And I can see why you're both set for temporary orders on a final hearing. Given the history of this case, I think it is in Juliet's best interest to make these order temporary. So these are not meant to be final. I think there's still a lot of information that the court should receive to make the best final decision. I don't think that information was provided today to the court, and you all may not even have it, which is probably why I didn't hear it. In any event, these are only temporary orders, and let me tell you why the court does this and does this in the best interest of Juliet. Number one, there is some evidence and testimony now on the record that there is possible physical danger and possible emotional damage living with Ms. Rangel. Now, whether that's true or not true, I guess the court is going to figure out and determine at the final hearing. But the flip side to that is that there is no evidence or testimony that there is possible emotional or physical damage or danger or emotional harm with Mr. Villasana. So these are just temporary, and I need you both, Mr. Rangel and Mr. Villasana, to know and understand that the laws and the policy of the state of Texas is that both parents have a close and continuing relationship with their children. So that is what's going to happen in this case. So I'm going to give you 2 dates, but one, you need to communicate by app close. 2, there is to be daily communication via video conference with the parent not in possession of the child. The court is going to do these temporary orders. The court will appoint Mr. Both of you have the same rights, duties, responsibilities, and obligations over Juliet, except that you, Mr. Villasana, will have the exclusive right to determine her residence. The person not in possession of Juliet will have daily communication with her by video conference at 7 p.m. or shortly thereafter. Visits will be standard per the Texas Family Code for parents that live more than 100 miles away. These are only temporary until we can get to the best final decision, having presented your full case to the court. The court believes keeping the status quo is in this child's best interest. The exchange should take place in Dilley by both parents or their designee. The court is going to want you all to flesh out by evidence and testimony any final allegations or conclusive allegations, I guess, proven allegations as to Ms. Rangel's spouses. The court heard that he served jail time, but no specific allegations. I don't know if this is a violent crime, not violent crime, or what the specifics are. It could be that it's not relevant. It could be that it's highly relevant. There's just so many unanswered questions, and this, I think, is the best decision at this juncture, given these facts and circumstances for this child. I'm going to give you 2 dates, but before I do, Ms. Rangel, I need to know more or less, when is your expected delivery date? I want to avoid setting anything on or near that date.
Yes, Your Honor. It's March 19th.
So give me the first date, Ms. Flores. Give me either the 10th or the 12th, the one that has less cases.
The 12th, Your Honor.
February the 12th at 9 a.m. The court is going to appoint an attorney ad litem because I think that person, I need an unbiased person to represent only the best interests of Juliet. There's so many unanswered questions still, and I'd like to get a better, crystal clear picture of everybody's situation. Mr. Montemayor, prepare these orders, get them on file by Friday. both the temporary orders and the appointment of an attorney ad litem. The court is going to pick the next person off the list. Mr. Montemayor, do you know of any lawyer that has a conflict with this case?
No, Your Honor, I didn't.
I'll pick the next person off the list. Now, Ms. Flores, give us so we're going to come back February 12th. What I need to hear from each person is how the visits are going, if there are any changes that should be made to the temporary orders, whether the attorney ad litem has had sufficient time to provide the courts further information. And then we need to come back sometime in April. Give me that setting, Ms. Flores.
April 16 at 2 p.m.
Ms. Rangel, do you have any questions for the court?
I can go to Juliet's psychiatrist appointment tomorrow in Laredo, correct? There's no.
Yes. Any objection, Mr. Montemayor?
No, Your Honor.
Right. You have any other questions, Ms. Rangel?
Okay. No. And since they're temporary orders, I should then inform her school to withdraw her completely from here, San Antonio.
They're temporary, so you can take those orders and they should give them the appropriate weight and validity, yes.
Okay. Sure. Thank you.
Mr. Biasana, do you have any questions for the court? Ms. Flores, does the court have Ms. Rangel's email address?
Yes, Your Honor.
All right, make yourselves available to whoever the court points as the attorney ad litem, and make Juliet available. Ms. Rangel, Mr. Villasana, I wish you both very well, but more importantly, I wish your daughter all the best. Yes, Ms. Rangel.
Yes. For visitations, for temporary orders visitations, they're going to be in Daly, Texas, the weekends.
The exchange will be there, yes. And
Okay,
you
yes,
can pick up, or
and-
you can designate someone that isn't your husband to pick up.
Okay. Daly, Texas. Are they going to be once a week or?
That language will specifically be in the order. So whatever the law, the family code says, 4 visits for parents that reside over 100 miles apart, that's what it'll be. Exactly what the law says, no changes.
Okay. Yes. Thank you, Your Honor.
All right. I wish you both well. More importantly, I wish your daughter all the best. You all have a
Thank
good
you.
night. Ms. Flores, have all cases been called on today's docket?
Yes, Your Honor.
All right. This now concludes the family law docket held in person and by video conference for Tuesday, January 13, 2026. The court continues to embrace the latest technology to provide safe and uninterrupted access to justice without delay. Today's docket was made possible by the appearance of counsel and parties and by the assistance, diligence, and preparation of the Webb County Court at Law 2 staff and the employees of Webb County that provide judicial support to the court. The court thanks you all. Have a good night.